Good morning, everyone. My name is Lawrence Bu. On my right is Dr. Anaka. On my left is Mr. Akom Ohose. We are members of this annulment committee. Get together today to hear the annulment proceedings in William Archibald Run against the Republic of Serbia, arbitration number 18-8. Is that correct? I hope that persons who are not involved in this matter should vacate now. And as you look across the table, you should know who is who. And I understand some of you may not have your name on the table, but could you identify yourself, sir? Oh, sir, you are the applicant in this case. Thank you. And the two gentlemen next to you are your? Okay, they are your advisors. Is that correct? Yeah, okay. Thank you very much, yes. So may I now invite the parties to introduce your team?
Yes, Mr. President. Stephen Amway from Squire Patton Boggs, and with your permission, I'll ask the other members of my team to introduce themselves.
Good morning, Mr. President, members of the tribunal. My name is Rostislav Pekaš, and I'm from Squire Patton Boggs.
Good morning, Mr. President, members of the committee. My name is Maciej Pustaj, also with Squire Patton Boggs.
Good morning, Mr. President, members of the committee. My name is Helena Švandová, also from Squire Patton Boggs.
Okay.
Good morning. My name is Igor Markicevic. I'm advisor to Mr. Rand.
Okay. So there's a Miss Brosko not here. Oh, there you are. Thank you. Okay, very good. Thank you. Sir,
Good morning.
Zurich. Yeah.
Mr. President, my name is Vladimir Đerić. I'm counsel for respondent, and I'm going to introduce the members of the team. On my left-hand side is Professor Petar Đundić, counsel. For respondent, Ms. Senka Mihaj, and also our colleagues from legal team, Mrs. Maria Alhaj and Mrs. Kristina Petronjević. Then we have our clients, Mrs. Olivera Stanimirović, the state attorney of the Republic of Serbia, then Mr. Marinko Čobanin, who is deputy state attorney of the Republic of Serbia, and Mrs. Milena Babić, also deputy state attorney of the Republic of Serbia, and finally we have Mrs. Violeta Maglov, who is assistant to the state attorney of the Republic of Serbia. Thank you.
Thank you very much. Thank you. Just any housekeeping matter from parties first?
None from the applicant. Thank you, Mr. President. No issues to
Nothing
discuss.
from our side. Thank you.
Very good. Well, just a reminder to everyone that these proceedings are being recorded and transcripts are being produced also. Recordings will be made available after the hearing. And there's also a video recording that will be made out of these proceedings, and it will be put on the ICSID website after these proceedings. Okay, and will be announced to the parties as and when they are so made public. Okay, on that note, I don't think is there any other housekeeping matters on that side. Otherwise, I think parties have agreed to the agenda for the hearing. Each party has been given 3 hours, I believe, to make their presentation. We have received 3 demonstratives from the applicant, and we have just received a bundle here of your presentation. So may I invite the claimants to please proceed.
Thank you, Mr. President and esteemed members of the committee. Let me begin by thanking you for the careful time and attention that you've paid to this important matter. It's an honor for us to be before you today. Our opening statement will be divided into 6 sections, which you see now on slide 2. First, I'll begin with an introduction. Second, I'll set forth the relevant background. Third, I'll review the legal standard for annulment. Fourth, and with your leave, Mr. President, I'll then pass the floor over to Mr. Pekaš and Mr. Pustaj to show that the tribunal failed to state the reasons on which it based its conclusions on quantum. Fifth, Mr. Pekaš will address the tribunal's manifest excess of powers by refusing to exercise jurisdiction over certain claims. And finally, Mr. Pekash will conclude with a brief section on if we are successful in this action, the tribunal's decision on costs must be annulled. So with that, I turn to the introduction. Members of the committee, this annulment action is about a tale of two parts of an award. One part of that award is carefully drafted, meticulously reasoned, and internally consistent. This is the part of the award relating to certain jurisdictional issues, state attribution, and liability. But the second part of the award, which largely relates to damages, is at places barren of any reasoning or analysis, of contradictory reasons, and of a manifest excess of powers. And it is the second part of this award that brings us here today. Now, as you embark upon your review of that second part of the award, let me emphasize here at the outset the importance of your role in this proceeding. You members of the committee are here today to undertake the critical obligation of maintaining the integrity of the ICSID system. And this is not just us saying it, this is how committees themselves in annulment actions have described their role. As you can see on slide 4 now up on your screen, and I quote, "The object and purpose of an ICSID annulment proceeding is the control of the fundamental integrity of the ICSID arbitral process in all its facets." That, members of the committee, is your broad mandate, the importance of which cannot be overstated. But of course, you also have a more specific mandate, which is found in Article 52(1) of the ICSID Convention, now on slide 5. That provision, of course, sets forth the grounds on which you should annul in an ICSID award. The two grounds on which we rely under Article 52(1) are subsections B and E, which provides that an award shall be annulled where the tribunal has manifestly exceeded its powers and where the award has failed to state the reasons on which it is based. Now, it is widely accepted in ICSID annulment jurisprudence that the failure to state reasons occurs in the following 4 circumstances. First, the absence of reasons for an award or its particular aspect. Second, contradictory reasons. Third, insufficient or inadequate reasons. And fourth, failure to observe relevant evidence. Now, the corollary to the annulment for failure to state reasons in Article 52(1)(e) is Article 48(3) of the ICSID Convention, which requires, and I quote, that the award shall deal with every question submitted to the tribunal and shall state the reasons upon which it is based. In other words, Article 48, which applies to the tribunal, is the flip side of Article 51(e), which applies to this committee. Members of the committee, all we ask in this proceeding is that you apply Article 52(1) in a fair, intellectually honest, and independent manner. By contrast, we respectfully submit that your decision should not be impacted by what I will call the who, the what, and the why. The who, the what, and the why are irrelevant. Now, what do I mean by that? It is irrelevant who the members of the tribunal were that drafted the award. We have great respect for each member of the arbitral tribunal that issued the award. But all that matters in this proceeding is whether any of the circumstances under Article 51 are present, without regard for who authored the award. It is equally irrelevant what the tribunal ultimately found for purposes of Article 52(1)(e). Again, all that matters is whether the circumstances under that provision are satisfied. And so, it may be that the tribunal's conclusion is perfectly correct, but it nevertheless would not matter under Article 51(e) if it failed to state its reasons for reaching that conclusion. Finally, the why. The why is irrelevant as well. Why some of the sections of the award are so well reasoned and others are so analytically deficient is irrelevant. Whether it's because there may have been different drafters of different sections in the award, or whether after deciding jurisdiction, state attribution, and liability, the tribunal may not have treated the damages section with as much attention. None of that is relevant. Again, all that matters is whether the circumstances in Article 52.1 are present. In applying those standards here, we will show you today that the award is fraught with a plethora of annullable errors. My colleagues will walk you through each of those errors today in detail, but I want to give you just some sense here at the outset of how manifest these annullable errors are. And I just want to preview for you two examples here at the outset. Example number one, the tribunal did not state any reasons whatsoever for rejecting claimant's valuation of 6 out of the 7 BD Agro assets and accepting respondents' valuations instead. Now, to understand this example, you need only know the following. The tribunal decided that Mr. Rand was entitled, as damages, to 75.87% of the equity value of BD Agro. And the tribunal held that to determine the equity value, it must first value BD Agro's assets, it must value its liabilities, and then it must subtract those liabilities from the asset, and that's the equity value. So far, so good. But the parties and the experts, and this is crucially important, disagreed strongly on the values of every category of assets and on the value of every category of liabilities. It was a major point of disputation in the arbitration. And consequently, the tribunal had to resolve those many competing arguments and pieces of evidence. What did the tribunal conclude? Now on slide 11, the tribunal announced its conclusion in one place and one place alone, and that's in this table, which is found on page 218 of the award. In this table, the tribunal adopted Serbia's valuations of BD Agro's remaining assets, and I want to be clear, other than the construction land, and I'm going to come back to the construction land in a minute. So it adopted Serbia's valuations. I'll just pause here for a moment. It adopted Serbia's valuations of the BD Agro remaining assets and rejected our valuations. Both were supported by extensive expert testimony. I'll also tell you, members of the tribunal, there is a similar table that's not shown here, but elsewhere in the award, where the tribunal did the same thing with respect to BD Agro's liabilities. So the question then is very simple. What did the tribunal say about its reasons for rejecting our valuations and accepting Serbia's valuations? The answer to that question, members of the tribunal, is on the next slide. Nothing. We have absolutely no idea how the tribunal reached this dispositive and outcome determinative conclusion. Contrast this with the depth and breadth of the first part of the award, which was meticulously reasoned and where its reasons for its conclusions were so clearly and robustly stated. Now, if we could go back 2 slides to that table again. You'll notice there's a related footnote at the bottom of the screen, which states that the table has been modified, quote, in light of the tribunal's conclusions above. The problem, members of the committee, is that there is absolutely no reasoning, literally none, on these issues above or anywhere else in the award. Now today, Serbia will tell you what it believes the tribunal's reasonings and stated reasons were. When this occurs, please ask yourself, where is the specific paragraph, the particular language in the award where the tribunal provides its reasons for rejecting claimants' valuations and accepting Serbia's? I can promise you, members of the committee, Serbia will not be able to point you to any particular paragraph because there is none. Serbia will guess, it will surmise, it will speculate, but that's all it will be able to do. Now, you may nevertheless ask, can't we as a committee simply assume the tribunal's reasons for adopting Serbia's valuations as the same reasons that Serbia set forth in its expert report that set forth these valuations? And the answer is categorically no. You can see this from Article 52, 1E itself, which states that the reasons must be in the award. An annulment committee is not permitted to divine a tribunal's reasons by looking into the parties' briefs or expert reports when the reasons aren't set forth in the award itself. Now, to understand why, ask yourselves as a hypothetical, and I acknowledge at the outset this is an extreme hypothetical, but taken to its logical conclusion, it makes the point. Ask yourselves, what would be wrong with an award that simply said the following? And let me just note, this is not supposed to just be the dispositive part of a larger award. Assume, for purposes of this hypothetical, that this is the entirety of the award. And it states, paragraph 1, the tribunal agrees with claimant that his 75.87% ownership is a protected investment under the BIT, and consequently the tribunal has jurisdiction over it. Number 2, the tribunal agrees with claimant that respondent breached the BIT. And number 3, the tribunal adopts respondent's expert's damages number, 14 million plus interest, and orders the respondent to pay that amount. It is hereby so ordered, so signed by the arbitral tribunal. I rush again to acknowledge this is an extreme example. But I am focused now just on the failure to state reasons with respect to the valuation table that I just described. And in that context, ask yourself, what would be wrong with this hypothetical award? Well, obviously, it would be an annullable award because it utterly fails to state any reasons. And just because a tribunal states that it agrees with the party's position, which is what this hypothetical award does not mean that the tribunal does not have to state its reasons, or that the party's reasons stated in a brief or an expert report is somehow assumed to be the tribunal's reasons. And here's the point. If that were enough, to just simply say you agree with the party's position but without explaining why, then this hypothetical award would be perfectly fine under Article 52(1)(e). And obviously, it is not. No one would seriously argue that such a hypothetical award would comply with the tribunal's obligation to state the reasons upon which its award is based. This hypothetical award would be immediately annullable under Article 52(1)(e). And as we will show you, this is exactly what the tribunal did with respect to numerous findings on damages, including the valuation table that we showed you a few slides earlier. All right, what does this mean? What is the consequence of this first example? It means that the tribunal's valuations of BD Agro's assets and liability, with the exception of the construction land, must be annulled. Well, what about the construction land? That takes me to my second example. Example number 2, the tribunal completely ignored the 2 most relevant comparable transactions on sales of land, so relevant that they were literally adjacent to and in close vicinity to the construction land, and were so relevant in time that these transactions occurred months before the valuation date. Now, I want to set the stage for this example so you can understand how important the tribunal's analysis that was either done or not done, how important that was to the ultimate conclusion and the dispositif in the award. To help me set the stage for this second example, please note that the construction land is BD Agro's single most valuable asset by a wide, wide margin. So what the tribunal did or didn't do in its analysis in evaluating this asset is the key driver to the damages that were ultimately awarded. Please understand how important the tribunal's analysis of this one asset was. Very importantly, in this regard, it is undisputed in the arbitration that the best evidence to value the construction land was actual comparable transactions. You can see on slide 18 here, Serbia's real estate expert stating precisely that, and you can see on the next slide where the tribunal agreed. So this was and remains an agreed proposition between both parties and the tribunal. And the question then is, what are these two pieces of critical evidence? What are these two comparable transactions? On slide 20, you will see references to both of them. On the left, you'll see a map. On the right, you'll see a zoom in of that map. And you can just look, members of the committee, and see where the land literally is right next to the farm. And in the other case, it's an extremely close vicinity to it. The land was literally sold only a few months prior to the valuation date, so extremely close in time. And it was Serbia's own expert who introduced these comparable transactions into the record. These pieces of comparable transaction evidence were discussed extensively at the hearing and in the parties' post-hearing briefs. And recall, this is the type of evidence that the tribunal said itself, and the parties agreed, was the highest evidentiary value in determining the most valuable asset of BD Agro. In short, it is difficult to imagine transactions that are more relevant than these. So we again come to the question, what did the tribunal do with this critical evidence on the most important valuation issue in the arbitration? And the again answer is nothing. We're not stating that we disagree with reasons why the tribunal rejected these pieces of evidence. We're saying these pieces of evidence were ignored entirely. They're not even mentioned in the award. And again, to underscore just how important this was to the outcome of the case, by ignoring these two pieces of evidence, the tribunal understated the value of BD Agro's equity by $45 million. Accordingly, the valuation of the construction land must be annulled for two independent reasons. The first, the tribunal failed to observe relevant evidence, and second, for contradictory reasons, because we just saw that the tribunal held that this evidence was the most relevant to valuing the construction land, and yet it didn't even mention them in the award. I'll also note that if you agree with us on this point, then you do not need to consider any of the other annulment grounds for the construction land conclusion. You can immediately annul the valuation of the construction land on this basis alone, and the rest of the arguments become moot. So again, I just offer those two examples. There are obviously many other annullable errors you will hear about today, but please notice, these two errors did not concern some peripheral issue in the arbitration. Exactly the opposite. These failures were on pivotal, outcome determinative issues. All right, let's pause here. Take a step back and return to the topic with which I began, and that is the importance of your role in this proceeding. The integrity of the system rests on parties having confidence that their arguments and their evidence, which they have put forward, have been thoughtfully considered. And an award where conclusions are made with no stated reasons whatsoever, where parties don't even know whether their arguments and evidence were even considered, is anathema to the ICSID Convention and the confidence that it is intended to inspire in its users. But perhaps most troubling is that lack of reasons or contradictory reasons regarding damages is even worse. Whereas here, the arbitral tribunal's findings on liability was based on egregious state conduct, where the state literally stole an investor's shares with no justification. The tribunal's now confirmed that. After the investor had taken over a company that was in physical and financial ruin, where he invested his blood, sweat, and equity to turn it into one of the most successful companies of its kind in Europe, where there were meetings at the privatization agency caught on audio recordings, which we played for the tribunal, clearly showing government officials were plotting against and planning to seize Mr. Rand's investment and acknowledging that what they were doing was illegal. And yet, despite that shocking conduct, the tribunal then only awarded a fraction of the actual damages that Serbia caused, but without even telling us how it reached that conclusion. Members of the committee, as I sit here today, I honestly don't know, in many cases, why the tribunal rejected the damages arguments and evidence that were so thoroughly discussed and debated in the arbitration. Or, as you will hear later, other cases where the tribunal's reasoning is contradictory, such that on one page they say A, and then on the next page they say B. And I'd also ask you to consider the future ramifications of your decision. We know there's no stare decisis principle in the system, but a decision from a committee this esteemed that overlooks this kind of lack of reasons, these contradictory reasons, would set a dangerous precedent, encouraging future tribunals and annulment committees to do the same, effectively reading out of the ICSID Convention Article 52(1). In conclusion, you, members of the committee, have a heavy burden. You are here to preserve the integrity of the ICSID system, to ensure that arbitral tribunals adequately explain their decisions and make it possible for the parties to understand the reasons for their decision, and which would facilitate review of the award. The measure of any adjudicative system is whether the parties can be confident that their arguments and evidence will be or already have been heard and fairly considered. And this heavy burden on you as a committee and on future committees is to preserve the ICSID standards of transparency and fairness for both claimants and states alike. With that, I turn to the background of the annulment action, Section 2 of our opening statement. Our story begins shortly before BD Agro was privatized in 2005. The farm was in a catastrophic condition and required significant investment. And let me just give you some sense of how catastrophic the situation was. Employees had no decent clothes and had not been paid literally for years. 6 inches of water on the floor of the kitchen. No heat in the main office despite extreme cold temperatures in the winter. The cows kept in places so small they could not move and when let out could barely walk. The farm's operating modes were outdated and ineffective, and BD Agro was in significant debt. The farm desperately needed an investor to inject funds and sound management into the project, and that's where Mr. Rand came in. In October 2005, the Serbia Privatization Agency held a public auction for 70% of the BD Agro shares. Now on slide 27, on the 4th of October 2005, Mr. Rand, a Canadian businessman who resides in Vancouver, won the auction and acquired beneficial ownership of 70% of the BD Agro shares. Fast forward a year, 29 August 2006, Mr. Rand increases his beneficial ownership to 75.87%, and that is what we define to be the beneficially owned shares. Let's fast forward again now to 2008. Mr. Rand provided loans to BD Agro in the amount of approximately 2.2 million euro to replace the entire herd at the farm. And as you'll later hear, members of the committee, these loans form the subject of part of this annulment action. Mr. Rand also secured further investments that transformed BD Agro into a state-of-the-art farm, which earned widespread praise. In this article, now on slide 31, titled "Where the Cows Listen to Beethoven," the reporter called BD Agro, quote, "the most modern cow farm not only in Serbia, but in Europe." Look how far it had come. As a result, Mr. Rand's investments, BD Agro became one of the largest milk suppliers in the entire Baltics. And it also owned, and this becomes critically important later, 290 hectare-acres of land near the Belgrade airport, which in 2008 was designated for construction of business and commercial areas, and this is what we define, and you've already heard me refer to as the construction land. Between October 2008 and 2012, Mr. Rand acquired an additional 3.9% indirect shareholding, which is what we call the indirect shareholding, and this too forms part of this annulment proceeding. So we'll come back to the indirect shareholding. Crucially important, on the 8th of April 2011, the last installment price of the acquisition of the BD Agro shares was paid, and as a result, and the tribunal confirmed this, all essential obligations under the privatization agency had been performed. And that's why it's so remarkable that almost 5 years later, on the 28th of September 2015, the privatization agency nevertheless terminated the privatization agreement, and as you can see on the next slide, 38, on the 21st of October 2015, the privatization agency seized Mr. Rand's beneficially owned shares. And then we come to, of course, the subject of this proceeding, which is the award, which was issued on 29 June 2023. And in the award, the tribunal rendered 3 key conclusions which are not challenged in this annulment proceeding. The first conclusion was that the actions of the privatization agency were attributable to Serbia and represented a breach of the Canadian-Serbian BIT. You can see on the next slide where the tribunal concluded that the acts were attributable to Serbia under Article 5 of the ILC Articles on State Responsibility. And on the next slide, where the tribunal concluded that the privatization agency wrongfully terminated the privatization agreement, slide 43 shows you where the tribunal concluded that the seizure of the beneficially owned shares violated the fair and equitable treatment standard in Article 6 of the BIT, and that takes us to the second key conclusion rendered by the arbitral tribunal that is not subject to this proceeding. And that is that the tribunal had jurisdiction over Mr. Rand's claims relating to his investment in the beneficially owned shares. On the following slide, you'll see where the tribunal upheld its jurisdiction ratione materiae over Mr. Rand's beneficially owned shares. Let's flip forward to slide 47, please. The third key conclusion that is not the subject of this annulment action: Mr. Rand is entitled to the amount of compensation corresponding to 75.87% of BD Agro's equity value as of the valuation date. And as you can see on slide 49, if we can flip ahead, the tribunal concluded the valuation date shall be 21 October 2015. And again, we'll come back to that because that date and where the evidence sits relative to that date is also a matter that is subject to this annulment proceeding. On slide 50, you'll see the tribunal concluded that BD Agro was a going concern as of the valuation date and therefore rejected the bankruptcy sales discount proposed by Serbia. And as I've already noted on slide 51, the tribunal concluded that the way to calculate the equity value of BD Agro was to value the assets, value the liabilities, and then subtract the liabilities from those assets. None of these conclusions reached by the tribunal is the subject of this annulment proceeding. What then is the subject of this annulment proceeding? First, The tribunal failed to state the reasons on which it based its calculation of BD Agro's equity value. And I've already covered that in my intro, and we'll cover it in more detail later in our presentation. If we move to slide 55, in addition, the tribunal manifestly exceeded its powers by refusing to exercise jurisdiction over the indirect shareholding in loans. And flipping ahead to slide 59, we'll conclude the background. So that, members of the committee, is the general background of the dispute. I know you've read the papers in detail, so I'm not going to spend more time on the issues that aren't the subject of this proceeding and the facts that gave rise to the award. What I want to do now is turn to the third section of our opening statement, which is the legal standards for annulment. Now, I know a committee this experienced is already familiar with these standards, but I think as you hear the arguments later, it's important to just revisit them briefly in advance. I've already shown you Article 50.2.1, but let's look at how committees have interpreted the standards of that provision. We start with Klockner versus Cameroon, where the committee found that the tribunal had failed to state reasons because the conclusion was simply asserted or postulated instead of being reasoned. And I quote, "The award in no way allows the ad hoc committee, or for that matter the parties, to reconstitute the arbitrator's reasoning in reaching a conclusion that is perhaps ultimately perfectly justified and equitable." It's the point I made earlier, but is simply asserted or postulated instead of reasoned. On slide 61, CMS versus Argentina, where the committee found that the tribunal had failed to state reasons because the reasoning could not be inferred from an implicit acceptance of one party's position. Recall back, members of the committee, to my hypothetical award. This is that exact proposition. As the committee observed, and I quote, "It is implicit in the reasoning that the tribunal may have accepted the interpretation of Article 2.2c, referred to in paragraph 92 above, but the tribunal nowhere addressed the point expressly. In these circumstances, there is a significant lacuna in the award, which makes it impossible for the reader to follow the reasoning on this point. It is not the case that the answers to the question raised, quote, can be reasonably inferred from the terms used in the decision. They cannot." Slide 62, Ramelli versus Kazakhstan. Annulment committees should not construct reasons missing from an award in order to justify the tribunal's decisions. And I quote, "If such reasons do not necessarily follow or flow from the award's reasoning, an ad hoc committee should not construct reasons in order to justify the decision of the tribunal." Slide 63, Mine versus Guinea. The committee found the tribunal had failed to state reasons because it applied a damages theory it had rejected earlier, making the reasoning contradictory. And I'd ask that you remember this, please, members of the committee, because this has direct application to one of our grounds for annulment. And I quote, "Having concluded that theories Y and X were unusable because of their speculative nature, the tribunal could not, without contradicting itself, adopt a damages theory which disregarded the real situation and relied on hypotheses which the tribunal itself had rejected as a basis for the calculation of damages." You're going to see later in our presentation today that exact scenario. 64, Pecasado versus Chile. The committee found the tribunal had failed to state reasons, applied a damages calculation it had rejected earlier, making the reasons contradictory. Again, very similar to one of our grounds for annulment that you'll hear about later. And I quote, "The tribunal's use of the expropriation-based damages calculation is manifestly inconsistent with its decision a few paragraphs earlier that such an expropriation-based damages theory is irrelevant. The issue lies precisely in the reasoning followed by the tribunal to determine the appropriate method of calculation, which, as demonstrated above, is plainly contradictory." Slide 65, Tidewater versus Venezuela. The tribunal had failed to state the reasons because it used a criteria in its valuation which it had previously rejected, making the reasoning contradictory. Yet again, members of the committee, you will hear this exact situation play out later in our presentation today. Slide 66, Mitchell versus Congo. The tribunal was found to have failed to state reasons because the reasoning concerning the existence of an investment was inadequate. 67, Paranco versus Ecuador. The tribunal had failed to state reasons because the reasons provided were insufficient. Slide 68, Enron versus Argentina. The committee found the tribunal had failed to state reasons because the reasons were insufficient, and I quote, "The committee considers it unclear whether the tribunal ultimately did make such a finding or not. To the extent the tribunal did make such a finding, the committee considers that it is entirely unclear on what basis that finding of law was made." Slide 69, Teco versus Guatemala. The tribunal had failed to state reasons because it ignored evidence. Of course, you'll recall during my introduction the classic example where this tribunal ignored the two key pieces of evidence that were of the exact category the tribunal held are the most relevant and on the most important damages-related issue. And I quote, "The committee takes issue with the complete absence of any discussion of the parties' expert reports within the tribunal's analysis of the loss of value claim. When the committee accepts that a tribunal, while the committee accepts that a tribunal cannot be required to address within its award each and every piece of evidence in the record," and this is extremely relevant to our case, quote, "that cannot be construed to mean that a tribunal can simply gloss over evidence upon which the parties have placed significant emphasis without any analysis and without explaining why it found that evidence insufficient, unpersuasive, or otherwise unsatisfactory." Here, members of the committee, I would note the arbitral tribunal in our case didn't gloss over those two key pieces of evidence. It didn't even mention them. Slide 71, Safraki versus UAE. The tribunal's failure to exercise jurisdiction constituted a manifest excess of powers. On the question of what manifest means, we know the case law. We know that you know the case law. Vivendi versus Argentina took the view that manifest should be interpreted to mean substantial or serious. But of course, in Occidental versus Ecuador, there was an alternative view taken where manifest was interpreted to mean clear or obvious. Members of the committee, that brings me to the end of my section on the legal standard for annulment. With your leave.
Interrupt here, I'm sorry to interrupt you. I noticed that we have not received the PowerPoint in print from the other side, and that everyone else has, so we would appreciate receiving a copy. Thank you.
Immediately?
The applicable procedure order did not provide for printed copies at all. We did provide printed copies for the members of the tribunal as a courtesy. We do not have any additional printed copies for Serbia. And
Have you sent the soft copy?
we did send a soft copy, obviously. Yes.
When was that?
Mr. President, I don't think that the claimant can provide even a piece of paper to the tribunal, not providing it to the other side. So it's obviously not a proper way to proceed that everyone else in the room has a paper copy of the PowerPoint and that we don't, because it's I have never seen that a tribunal or a committee would receive a piece of paper without having a copy for the other side. Thank you.
Thank you, Mr. Chair. Mr. Pekov, can this be arranged within the next 15 minutes? We did start early, so we
Yes, no,
can
but
stand down
we
for a
do
few
not have
minutes.
access to a printing machine here. That's
Let me propose this.
Okay.
Let me propose this. Why don't we call our Madrid office right now, send them the soft copy, ask them to print it out, and rush it over here as quickly as possible?
Yeah. Meanwhile, we can have
If you're willing to share, we would be most grateful.
and the soft copy has been sent. Yeah?
Yes. No?
Because I find it very troublesome to actually flip so many pages. I normally follow because some pages have one sentence.
Yeah.
So it's really quite quite heavy burden to carry.
Heavy burden indeed.
Yeah. So you can send off the soft copy, that would be appreciated. Yeah. And upload it to the box. Yeah, immediately. Thank you. So do you have the hard copy now?
Yes,
Yeah.
thank you very much.
Okay. Are you ready to continue? Is it okay? And meanwhile, let them arrange for the other hard copies to be sent to the respondent. Okay? Please. Thank you. Please make sure that whenever there's anything presented to the tribunal, the other side also have a similar copy. Okay? Thank you.
Absolutely. As I said, members of the tribunal, that committee, that takes me to the end of my presentation on the applicable legal standard. With your leave, Mr. President, I would turn the floor over to Mr. Pekash to then apply the standards that I've just reviewed with you to the award in this case. Thank you.
Thank you.
Going forward, if there's any complaint about no documents, please alert us earlier rather than later. Okay?
Yes,
Thank
sure. I didn't want to interrupt my colleague.
Very well. Okay.
Thank you, Mr. President. In the first part of my presentation, I will show the members of the committee how the tribunal failed to state reasons on which it based its conclusions on quantum with respect to the construction land. As Mr. Anway explained, the construction land is the single most important item on BD Agro's balance sheet. When addressing the issue of the valuation of the construction land, the tribunal first identified 6 principles for its valuation. And let me state at the outset that we are not taking issue with these principles. We are taking issue with the fact that the tribunal later contradicted those very same principles when it accepted Serbia's valuation. So in a nutshell, what happened is that these principles were announced when the tribunal spelled out the reasons for its disagreement with certain aspects of the valuation proposed by claimants and their valuation expert, Dr. Hearn. And then the tribunal accepted Serbia's valuation, even though Serbia's valuation contradicted these very principles. So the tribunal stated A when rejecting our figures, and then contradicted the A completely when accepting Serbia's figures. And that is the problem. That is the error which warrants annulment of the respective part of the award. So the first principle is that valuation should be based on actual comparable transactions as the primary most relevant evidence. This was actually undisputed as between the parties. The second principle, which was also undisputed as between the parties, was that asking prices have the lowest evidentiary value, and the valuation should not rely on asking prices with no corresponding information about dates and sources of these prices. Principle number 3, the valuation should only rely on evidence from comparable areas. And there was a disagreement between the parties whether an area in the vicinity of the community of the Banovci, where the BD Agro land was located, and this other locality is called Batajnica, whether that was comparable or not. Our position was that it was comparable. Serbia's position was that it was not comparable, and the tribunal said that it was not comparable. Principle number 4, the valuation should only rely on evidence information available on or before the valuation date. Principle number 5, a discount is justified where evidence used in the evaluation relates to comparable land with better access to infrastructure. And principle 6, smaller land plots are more valuable per meter squared than comparable larger land plots. So these were the 6 principles. Now, let me turn and provide more details on the fundamental issue which was already described by Mr. Anway. The tribunal ignored two highly relevant actual comparable transactions with land adjacent to and in close vicinity of the construction land, which preceded the valuation date by only 2 and 3 months. The reason why this description on this slide is relatively long is that we want to show that these two transactions ticked all the boxes identified in the tribunal's principles. These were actual transactions, not just asking prices. They were with land located in the same locality, and they preceded the valuation date, and they were very valuable from that perspective also because they preceded it by a very short period of time, just 2 or 3 months. So from all the transactions which were offered to the tribunal, these two were the most comparable. These two transactions were actually identified originally by Serbia's expert, Mrs. Ilic, who put their description in her expert report. You can see the excerpt on this slide. Obviously, the facts regarding these two transactions were not disputed between the parties. Here is where the land plots were located. Mr. Anway already showed you this slide. You can see that the comparable land is the two blue parts. The one adjacent to BD Agro was sold at a price of 28.4 euros per meter squared, and the one further away was sold for a higher price of almost 34 euros per meter squared. Again, none of that was disputed. At the hearing, Dr. Hearn expressly stressed the importance and relevance of these transactions. This is shown not only here on the excerpt from his opening presentation, but also the slide I was showing you earlier and Mr. Anway was showing you is actually taken from Mr. Hearn's presentation at the hearing. So the members of the tribunal were able to see the same pictures that I just showed to you. And Mr. Hearn explained that this is an issue that he was not able to respond to in his reports because it came too late. But he thought that Mrs. Ilic did identify some transaction evidence that is indeed very relevant. And then in the highlighted part, he explained why he thought that was so relevant. We also extensively referred to these transactions in our post-hearing submissions. And the tribunal did not address at all these two transactions in the award. You know, the tribunal addressed other types of evidence which were given significantly less emphasis by claimants and Serbia, but for some reason it did not address at all these two transactions which were mentioned by both parties. And obviously the two transactions were also extensively discussed during cross-examination of the experts. I'll just recall that the ad hoc committee in Teco versus Guatemala very clearly stated that tribunals commit an annullable error when they ignore relevant evidence. Mr. Anway already showed you the excerpt. I will not repeat that. But it is very clear that when both parties present something as a key piece of evidence, the tribunal has to say something on it. The tribunal cannot just leave it without any comments. The tribunal may agree or disagree, but the tribunal has to say something and the tribunal has to explain its agreement or disagreement. This is not what the tribunal did here. So the first issue there is the absence of any comments. And the second issue is the tribunal contradicting itself, the tribunal contradicting its own principles, because if the tribunal had followed its own principles, it had to conclude that this was highly relevant. I already explained that these transactions comply with the first principle because they are actual transactions. They comply with the third and also the second principle, which is a corollary to it. They are not asking prices. They also comply with the third principle because it's from a highly comparable area, and they comply with the fourth principle because they predate the evaluation date. Members of the committee, we submit that that is the most important issue we have with the evaluation of the construction land. I will continue with other reasons, but if you agree with us on this one, you don't even need to decide on what I'm going to describe in the following 10 minutes, because this error with respect to the valuation of the construction land is sufficiently serious to warrant annulment of the respective part of the award. But I will turn to these other issues nonetheless. When I was introducing the principle number 3, which is about comparable areas, I specifically mentioned the land in Batajnica. So the tribunal concluded that that land was not comparable, but then accepted Serbia's reliance on an asking price for land in the same area. On the following slide, you can see that claimants and their valuation expert relied on evidence from comparable land transactions with land in the Batajnica area. That obviously is in addition to the 2 highly comparable transactions taking place in Dovanovci itself. The tribunal concluded that there were allegedly major differences between the Batajnica land and the construction land. This obviously is a conclusion to which the tribunal was perfectly entitled. But then what the tribunal was not supposed to do is to rely on Serbia's asking price for a land plot in Batajnica. Simply put, the tribunal cannot say that Batajnica land plots are not comparable when claimants refer to them, but then accept that they are comparable when Serbia refers to them. The ad hoc committee in Tidewater partially annulled the award as contradictory because the tribunal used an element for its determination of compensation that it had rejected earlier. And this is exactly what happened here with respect to the Batajnica area. The tribunal rejected Dr. Hearn's reliance on the Batajnica transactions also because they allegedly post-dated the evaluation date. Again, this is the tribunal's principle number 4. The tribunal is perfectly entitled to that principle, but then it is supposed to apply this principle even-handedly to both parties. And this is not what happened because the tribunal then accepted Serbia's reliance on asking prices with unknown dates. So what we can see on the following slide is that the tribunal rejected evidence from the Batajnica transactions because it concluded that they post-dated the valuation date, but then accepted Serbia's asking prices without knowing whether they predated the valuation date. What you can see here is an excerpt from this table. This is a table that you will see quite often on our slides, because the tribunal's valuation of the construction land actually relies only on these 5 sources of data. These are 5 asking prices for land which the tribunal thought was comparable. But by accepting them, at least with respect to the Batajnica land, it contradicted itself. And here, with respect to the first 2, it also failed to apply its own principle number 4, because what we can see with respect to the dates of these asking prices is that they are from the year 2015, but the exact date is unknown. And the valuation date is October 2015. Therefore, the tribunal couldn't have known whether these prices predated October 2015 or post-dated October 2015. And if they post-dated, then obviously they needed to be excluded on the basis of the tribunal's principle number 4. The tribunal also rejected the reliance on the Batanica transactions because they are allegedly different from property valuations based on international standards. But then the tribunal accepted Serbia's reliance on asking prices, and asking prices are also different from property valuations based on international standards. We can see that on the following slide. It's a quote from Article 693 of the award, where the tribunal says that explaining why the Batanica transactions are not comparable, that they are based on value assessments by the tax administration for determining the tax on property transfer. They are thus different from property valuations based on international standards. Again, we do not dispute that conclusion, but what we dispute is that if that was the tribunal's view, how come the tribunal could have accepted asking prices proposed by Serbia? Because asking prices are also different from property valuations based on international standards. Actually, asking prices do not involve any valuation whatsoever. They merely indicate a price at which the owner states to be willing to sell his or her property. They are even more detached from valuation than tax assessments. Then the tribunal also refused Dr. Hearn's reliance on the first Confinex valuation because it was not based on comparable transactions. But then it accepted Serbia's valuation, which, as I have already shown to you, was based solely on 5 asking prices and no comparable transactions at all. So this first Confinex valuation is a valuation which was prepared by a company called Confinex, that's hence its name, in 2015. Serbia accepted the first Confinex valuation and a pre-packed reorganization plan submitted by the new Serbia-appointed management of BD Agro in January 2016. And the plan was also approved by BD Agro's General Assembly, which at the time was fully controlled by Serbia. That was post-expropriation of BD Agro. So we submitted that was a highly relevant piece of evidence, also due to the acceptance of the evaluation by Serbia contemporaneously. The tribunal rejected the first Confinex valuation because it stated the valuation was not based on evidence from comparable transactions. But then it based its valuation of the construction land solely on the 5 asking prices identified by Serbia. And to repeat, asking prices are not comparable transactions. The tribunal also rejected Dr. Hearn's use of the Mergut valuation, another valuation prepared contemporaneously, because Mr. Mergut relied on asking prices. But then, as I already told you, the tribunal accepted Serbia's valuation, which was based solely on asking prices. The Mergut valuation was prepared as of 31st of August 2014, so it predated the valuation date by approximately 2 months. Again, it was a contemporaneous piece of evidence. And the tribunal said that it rejected actually this valuation because it was only based on asking prices. Again, something to which the tribunal was perfectly entitled. But then the tribunal was required to apply the same approach to Serbia's figures, and as I have shown you, Serbia's figures are based just on 5 asking prices. So how come that asking prices are not good when it comes to Mr. Mergut's valuation and Dr. Hearn's reliance on that contemporaneous valuation, but suddenly they are good enough for the tribunal when it comes to Serbia's valuation? That is a very clear contradiction. And this is even more problematic because the prices that Serbia's expert, Mrs. Ilic, presented were taken from alleged advertisements which did not provide sufficient information about the sources or dates of these asking prices even. because some of the advertisements did not include a date. None of the advertisements shows the location of the advertised land plots, and the description of the advertised land is extremely brief. The tribunal also ignored the second Confinex valuation. We've already discussed the first Confinex valuation. The second Confinex valuation was prepared as of 31st December 2015, so this post-dates the valuation date by 2 months and a half. And Dr. Hearn relied on it not as a source of data, but merely as a confirmation for his number. The tribunal ignored the second Confinex valuation when valuing BD as gross land completely. But the tribunal actually did use the second Confinex valuation as evidence for the value of BD Agro's liabilities. So the same piece of evidence was ignored when relied upon by Dr. Hearn and the claimants for the valuation of the construction land, and not a word was said about whether this is convincing evidence, not convincing evidence, and why. But then the same piece of evidence was relied on by the tribunal with respect to the list of and valuation of BD Agro's liabilities. And we say this is a contradiction again. The tribunal must explain why a piece of evidence is good enough for purpose B, but not for purpose A. If the tribunal just keeps silent about that, it's actually a combination of contradiction and ignorance of evidence. That brings me then to another major issue with the valuation of the construction land done by the tribunal. And this is a 30% discount that the tribunal applied to the value of the construction land. And we submit that the reasons for that discount were contradictory, insufficient, and inadequate. And as a result, that part of the valuation must also be annulled. The 30% discount was proposed by Mrs. Illich. And the tribunal's acceptance of a discount was based on an alleged lack of infrastructure with respect to the construction land. But it contradicts the tribunal's decision to apply the same 30% discount to BD Agro's other construction land in Dobanoci, which has access to infrastructure. So when I was showing you the picture of Dobanoci and where the comparables were located, there were what we call construction land was marked there as zones A, B, and C. And there is the so-called other construction land, which is the land on which the farm is built. And that has perfect access to infrastructure, obviously. You cannot operate a farm without having access to infrastructure. And the farm is roughly in the middle of the construction land. But that's not the only contradiction. In fact, the tribunal should have applied a premium rather than a discount when valuing the construction land, because the land plots were smaller than Mrs. Illich's comparators. So the median size of BD Agro construction land is approximately 17,000 meters squared. And the median size of construction land is 30,000. So the comparators used by Mrs. Illich were actually larger than the land in Domanoc. And the tribunal also failed to assess whether a premium based on smaller size, the premium I just discussed, would outweigh a discount for the alleged difference in access to infrastructure. So even if we accepted that there was difference in access to infrastructure, and even if we accepted that that warranted a discount, it stems from the principles that the tribunal itself announced, that the tribunal should have compared that discount to the premium stemming from the smaller size and, opine on it, provide some reasons for its decision. It did not do that at all. The tribunal did not provide any reasons for accepting the 30% magnitude of the discount proposed by Mrs. Illich. All we have on that point is this one sentence in paragraph 697, which says, failing more precise indications in the record about the size of this deduction, it appears reasonable to the tribunal to accept the 30% discount applied by Mrs. Illich. So does it mean that if Mrs. Illich had proposed a 99% discount, the discount would have been acceptable, failing more precise indications in the record about the size of this deduction? Because what happened is that we were arguing there should be no discount. So in other words, zero discount. Serbia was arguing 30% discount. The tribunal concluded, contradicting itself, that a discount should be applied. But then the next step was for the tribunal to justify why it is 30% and not 25%, 20%, 15%, 50%. And all the tribunal said is this one sentence, failing more precise indications in the record about the size of this deduction, it appears reasonable to the tribunal to accept the 30% discount applied by Mrs. Illich. With all due respect, this is not sufficient reasoning. And this is not sufficient reasoning on an issue which obviously has very significant monetary implications for damages. And I will come to that later. The ad hoc committee in Perenco versus Ecuador confirmed that tribunals cannot adopt a value as opposed to any other value without any explanation. And this is exactly what the tribunal did in our case. The tribunal had the choice between two values, between 0 and 30, and it said it cannot be 0, therefore it is 30. And this is not sufficient reasoning. This is precisely adopting a value as opposed to any other value, to another value, without any explanation other than, oh, I have the choice between two values, I pick this one. And that is not reasoning. The reasoning would be to say 30% is an appropriate discount because A, B, C, D. This did not happen. The ad hoc committee in Soufraki confirmed that insufficient and inadequate reasoning that cannot be a reasonable basis for the solution arrived at also warrants annulment. This is the legal standard, the one in Perenco and Soufraki, which we ask the committee to apply. So now let me summarize. The tribunal accepted Mrs. Illich's valuation of the construction land, even though that valuation contradicted the tribunal's own 6 principles for its valuation. So the first principle, to recall, the valuation should be based on actual comparable transactions as the primary most relevant evidence. Mrs. Illich's valuation does not rely on any actual comparable transactions. This is undisputed. The second principle, asking prices have the lowest evidentiary value, and the valuation should not rely on asking prices with no corresponding information about the dates and sources of these prices. Again, Mrs. Valich's valuation relies solely on 5 asking prices, even though relevant comparable market evidence was available. These are the 2 transactions in Dobanovci at the very least. Mrs. Illich did not provide relevant information about the dates and sources of asking prices she relies on. what you have here is all, actually, that the tribunal had at its disposal with respect to the 5 asking prices on which Mrs. Illich based her valuation. And she did provide some links, actually, to the internet where she found that information. So first, this is probably not the correct way to submit evidence into the record, but even leaving that aside, when we clicked on the links, we saw that there were no dates in the listings on the first 2, and then the links with respect to the other 3 were non-functional. No information was available on the websites indicated here. So all the tribunal had at its disposal is really the information on the type of land, city, municipality, cadastral municipality. For 3 of them, it did not even have the address. For the first 2, there was some rough address, but this is not an address like street number, obviously. This is just a broader area where this might be located. The size was indicated, the asking price was indicated both for the whole land plot and per meter squared. There also was some adjustments proposed by Mrs. Illich, etc. And the date was identified just by the year for 2 out of the 3 transactions and by the date for another 3. So we submit that the information provided on this slide is not sufficient, actually, to satisfy the tribunal's second principle. The third principle is that the valuation should only rely on evidence from comparable areas, and this is the Batajnica issue, which I already discussed. As you can see here, one of the 5 transactions occurred in, actually, apologies, that was not a transaction, one of the 5 asking prices related to land in Batajnica. The tribunal provided no explanation whatsoever why that was okay, despite its finding with respect to the Batajnica area. In fact, it's likely that the tribunal did not even notice that one of the asking prices related to Batajnica land, but I should not be speculating. The fourth principle, the valuation should only rely on evidence information available on or before the valuation date. That's also something I already explained. The first 2 prices do not have a date. They just state the year. Because the valuation date falls within that year, it means the tribunal did not know whether the asking prices were from before or after the valuation date. And there's no way to figure that out from the text of the links provided in the table. Now, the fifth principle, a discount is justified where evidence used in the valuation relates to comparable land with better access to infrastructure. This is the 30% discount which was proposed by Mrs. Illich. It was accepted by the tribunal, even though there is no evidence of differences in access to infrastructure between the construction land and the land plots used by Mrs. Illich. And this is because we do not know where Mrs. Illich's land plots actually are. So how can then the tribunal say that they had better or worse access to infrastructure without knowing where they were? Second reason, as I already mentioned, BD Agro's farm, which is labeled other construction land in the tribunal's analysis, had full access to infrastructure, and the construction land was just adjacent to that other construction land. Mrs. Illich's valuation also contradicts the sixth principle, which is that smaller land plots are more valuable per meter squared than comparable larger land plots. I already explained that. The land plots included in the construction land were smaller than Mrs. Illich's comparables. Therefore, there should have been a premium, but it did not happen. So this is just a summary of how each of Mrs. Illich's 5 asking prices breaches the tribunal's valuation principles. We already presented that in our submissions. And you can see that most of the asking prices actually breach all 4 principles with respect to appropriate data. So both all of the first, second, third, and fourth valuation principles are breached by asking price 1. The same holds true for asking price 2. And then the remaining 3 asking prices comply with the fourth valuation principle because we know the date, but they still do not comply with the first 3 principles. What is the impact of it all? The tribunal's contradictory, irreconcilable, and/or insufficient reasoning and its ignoring of key evidence depressed the value of the construction land by 40.5 million euros. Frankly, this is why we are here. And you can see it on this graph. So what you can see on the graph, because sometimes it may be confusing that the award speaks of prices per meter squared, and sometimes in absolute numbers. So what is here is the value of the land implied by the prices per meter squared indicated in the various sources of data. What you can see at the left is the tribunal's value in the red, so it's 41.9 million euros. And that is after deduction of the 30% discount, which is showed on top of it. That's the 18 million euros on top of the 41.9. And then further to the right, you can see in blue the prices implied by the various sources of data. And we would obviously draw your attention on the 2 columns marked in red. And this is the Dobanowski transaction 1. That's the one with the land immediately adjacent to the farm. And then the Dobanowski transaction number 2, which is a bit further away, but still in the Dobanowski area. What you can then see in the middle, the green column, is the price or the value which was proposed by Dr. Hearn and claimed by the claimants. So one thing which is important is that claimants actually are reasonable. They are not going for the highest price, which would be in the upper range of the Batajnica transactions. They really are in the middle of the prices implied by comparable transactions. The graph also shows that if the tribunal had not contradicted itself, it would have needed to accept, at the very least, the Dobanowski transaction 1 and Dobanowski transaction 2. So it should have placed the value somewhere between 79.3 and 94.9 million euros. And this failure to consider these 2 transactions is really unexplained and unexplainable. Because as I showed, these 2 transactions really tick all 4 boxes that the tribunal itself said it's going to use with respect to determining what transactions are comparable and what transactions are not. To repeat, actual transactions, comparable land in the vicinity, not asking prices, and dated immediately prior to the valuation date. This is great evidence of the price that a buyer was willing to pay and the price at which a seller was willing to sell in the real world. And therefore, that would have been the proper basis for the tribunal's determination. And obviously, there's no reason to apply any discount, because the discount is applied for what? For better access to infrastructure. But there's no reason to opine that land which is situated literally across the street from the land subject to the tribunal's valuation would be priced any differently, and that some discount should apply. So that, members of the tribunal, concludes my submissions on the valuation of the construction land. And with your permission, I will pass the floor to Mr. Pustai, who, or unless you want to take a break, we'll address you on.
We will take a break for a while to for the transcription team. Everyone to rest for a while, and then we'll resume with you. Okay, with Mr. Pustai. Okay, I think it's 30 minutes, right? On the schedule, we have 30 minutes, but I think we can take 20. Would that be okay? Yeah.
And good morning again, members of the committee. It's an honor to appear before you today. In my part of our presentation, I'll address the remaining 2 points related to the tribunal's failure to state reasons, and that is the fact that the tribunal failed to provide any reasons for its valuation of BD Agro's remaining assets, and this means now assets other than the construction land, and that the tribunal provided contradictory and insufficient reasoning with respect to its valuation of BD Agro's liabilities. So I'll start with the first of these 2 issues, and that's the fact that the tribunal did not provide any reasoning for its valuation of BD Agro's remaining assets. The table on the screen you've already seen in Mr. Enway's part of our presentation. So the assets that are highlighted here in this table are the ones for which the tribunal did not provide any reasoning whatsoever. Now, while that's the case, as you know from our submissions, Mr. End only requests annulment of 2 of these categories, and that's category Novi Bečej and current assets. And I'll address those 2 in a moment, and you can see them highlighted by the red frames here on the slide. As for the remaining categories, Mr. End does not request the annulment of the tribunal's valuation, even though there was no reasoning provided, because these assets were valued similarly to what parties actually argued in the arbitration. So, trying to be economical here. Move to the next slide. So what you can see here, members of the committee, is again something that we've already seen. It's the only explanation provided by the tribunal for its valuation of all these other assets. And as you can see, it's 1 sentence in 1 footnote in the award. Now, this fact on its own should give anyone a pause. It's simply untenable that the tribunal would be able to provide reasons for valuation of 6 different categories of assets in 1 sentence in 1 footnote. Now, but even putting that aside, Mr. Enway already addressed this point, let's see what it is that the tribunal actually said in this 1 footnote. So the footnote states the following. This table is based on the table in Cowen Expert Report 3, paragraph 4.4, after adjusting it as necessary in light of the tribunal's conclusion above. Now, members of the committee, there is a number of issues with this statement. First, it is unclear what the tribunal meant when it stated that the table was, quote-unquote, based on the table provided in Mr. Cowen's report. Second, the tribunal did not provide any explanation for why it believed that the valuation of BD Agro's remaining assets should be based on Mr. Cowen's valuation rather than the valuation prepared by Dr. Hearn, i.e. claimant's expert. And third, as already mentioned by Mr. Enway, it's completely unclear to what conclusions above the tribunal intended to refer, as there is no discussion of these categories of assets anywhere else in the award. Not above, not below, not anywhere. As you can see on this slide, previous ad hoc committees expressly confirmed that if there is no express rationale for the conclusions with respect to a pivotal or outcome determinative point, and this is clearly the case here, we are talking about 6 out of 7 different categories of assets, then the annulment must follow. And we respectfully submit that the committee in this case should follow this conclusion and annul the tribunal's valuation of these Novi Bečej and current asset categories. And I'll now turn to these categories in a bit more detail. So first of these categories, Novi Bečej, as you can see on this slide, the tribunal did not explain either what specific assets it allegedly or supposedly included in this category, nor did it provide any reasoning for the value, 0.2 million, that it assigned to this category of assets. So the first issue, it's unclear which specific assets were included in the Novi Bečej category, because the parties approached valuation of Novi Bečej differently. And the tribunal did not explain which of the approaches is actually adopted. So as you can see on this slide, claimant's valuation of Novi Bečej included BD Agro's co-ownership of the Đunđerski castle, so co-ownership of a castle, and then also ownership of agriculture, forest and construction land. Serbia's valuation, on the other hand, did not include the castle. And because the tribunal did not provide any reasons for its valuation, it's unclear whether this valuation includes the castle and or the land, and if not, why. And at the same time, it's completely unclear how the tribunal arrived to the value that it assigned to these assets, being the 0.2 million euros. Just to provide some context for this number, the difference between the value assigned by the tribunal and the value that at which claimants valued the Novi Bečej category is certainly not negligible. As you can see on this slide, the difference is 600,000 euros, while the total amount awarded to Mr. End in the arbitration was 14.6 million. So this is not an insignificant difference. Now moving to the second category, current assets, the tribunal again did not explain what assets are included in this category or how it estimated the value of these assets. So like with the Novi Bečej, both parties included slightly different assets in this category of assets, and they valued them differently. And you can see claimant's valuation there on the left and Serbia's valuation there on the right. And let's stay on this slide for a moment. And members of the committee, as you see, the claimant's valuation here is a net book value of these other assets. And the reason why I'm stressing is that you may hear from Serbia later today that the tribunal rejected Dr. Hearn's valuation because it was based on the discounted cash flow method. So members of the committee, if you hear that today, just remember this table.
Mr. Pasti, you want to slow down a little bit?
Sure. Apologies. So members of the tribunal, if you hear Serbia telling you later today that the tribunal did not use Dr. Hearn's numbers because they were based on DCF, just remember this table. This table clearly showed that Mr. Hearn used asset-based approach. And yes, he did use DCF as an alternative for some assets, but all assets were valued by Mr. Hearn also using the asset-based approach. Let's move to the next slide, please.
But just pausing there. If we look at the figures, are they not around the same?
So the difference is 6.6 million on claimant side. You can see the number on the very left, and 5 million on the respondent. So the difference is 1.5 million, just on this one category of assets. And so, as I said, the tribunal did not provide any explanation for which of the approaches it believed was correct. And as a result, it's unclear what assets are actually included in this current assets category in the award. And just getting to your point here about the difference. So as I said, the difference between the valuation that claimants proposed and the tribunal now eventually adopted is 1.6 million. And again, this needs to be seen in the context of the total amount awarded to Mr. End, which was 14.6 million. So, this, even though it may seem that 1.6 million is not a big number, in the context of the total amount awarded to Mr. End, it certainly is a significant number. And that brings me to the conclusion of the first topic. So on this slide, you can see the summary of the negative impact for both of these issues. So valuation of Novi Bečej and current assets. And as you can see, the total difference is 2.2 million. And just to provide a slightly different view on this, so that's 15% of the total amount awarded to Mr. End. So just these two categories of assets amount to a number that corresponds to 15% of the total amount awarded to Mr. End in the arbitration. Let's move to the second topic that I'll address today, and that is the tribunal's contradictory and insufficient reasoning with respect to BDA gross liabilities. Now, as Mr. Pekač already explained, the tribunal refused to rely on the evidence or information post-dating the valuation date. However, the tribunal then contradicted itself because it used such evidence to value BDA gross liabilities. So you can see the tribunal's conclusion on this slide. We've already seen that, so we can move on to the next slide. So first, the tribunal accepted Serbia's value of BDA gross debt to Banca Intesa, even though this additional value was based solely on events and evidence post-dating the valuation date, and you can actually see that here on this slide with the excerpt from the award. In addition, the tribunal also relied on the second Confinex valuation. You've heard Mr. Pekač describe it in detail today. So this valuation was prepared only in January 2016 and based on the financial information as of 31st December 2015. So both these dates post-date the valuation date, but the tribunal used it for valuation of BDA gross liabilities either way, even though it stipulated that it will not rely on evidence post-dating the valuation date. So if we move on. Same with respect to BDA gross financial statements for the year 2015. Again, financial statements are prepared as of the last day of the year, so 31st December 2015. So this is 2 months after the valuation date. Yet the tribunal uses this document and this information as of this date to value BDA gross liabilities. And again, the fact that the tribunal is using, in contradiction with its conclusion that the evidence post-dating the valuation date should not be used, the fact that it then used such evidence actually inflated BDA gross liabilities by 4.6 million euros. So if the tribunal haven't used this evidence post-dating the valuation date, the valuation of BDA gross would actually be higher by 4.6 million euros. And now I would like to quickly go through some of the specific issues related to tribunal's valuation of individual liabilities. So first, the tribunal provided contradictory reasoning for its calculation of redundancy payments. So this is one of the items in BDA gross liabilities. And as you can see on this slide, the tribunal concluded that the redundancy payments should be included in BDA gross liabilities based on Annex 1 of the privatization agreement. Even though the tribunal concluded before in the award that the privatization agreement ceased to apply upon the full payment of the purchase price in 2011. So that's 4 years before the valuation date. So on one hand, the tribunal concluded this privatization agreement was no longer applicable as of the valuation date. But then it concluded that the redundancy payments should be included in BDA gross liabilities as of the valuation date based on the privatization agreement, which supposedly did not apply as of that date. So we respectfully submit there is a clear contradiction in the tribunal's reasoning on this point. Again, the impact of this contradiction is not insignificant. The tribunal decreased BDA gross equity value by including the redundancy payments by 0.7 million euros. Next issue, the tribunal provided contradictory reasoning for its calculation of the conversion fee, so another line item in BDA gross liabilities. And first, the tribunal concluded, and you can see the conclusion here on the screen, that the conversion fee should be calculated using the value of the land based on previous year's tax assessment. So there is a calculation of a conversion fee. Conversion fee is a fee that is being paid for conversion of agriculture to construction land. And the tribunal says for that calculation you rely on the value of the land stated in tax assessments. But then the tribunal adopted the conversion fee calculated by Serbia's real estate expert, Ms. Ilic, which, and this is undisputed, was not based on the tax assessments. And you can see what actually Ms. Ilic did here on this slide, so I'll just walk you through first example that you can see there. So you can see the calculation of the conversion fee by Ms. Ilic on the left, and you can see the highlighted number there, 4.3 euro per meter square. So that's the price for meter square of the land used by Ms. Ilic. And this is a valuation that Ms. Ilic herself provided. This is not a tax assessment. As you can see, the tax assessment was actually significantly lower at 0.72 euros per meter square. So in this one example, the difference between the conversion fee calculated according to the rule that the tribunal established and the number that the tribunal adopted at the end is approximately 150,000 euros. So conversion fee adopted is 173,000. You see that on the left. And the conversion fee that would follow from the calculation following the tribunal's own rules would be 29,000. The second example you can see there, that's the same issue. Again, the value used in the calculation is not from the tax assessments, the 3.4 euros highlighted. The correct number should have been 1.94, and you see that there a difference in the calculation is approximately 1.3 million euros. So we can move to the next slide. And so just to recall, we showed you the Tidewater award, I think, twice now. But again, this is the exact issue that was discussed in the Tidewater. So first, the tribunal concluded that the valuation should be done using certain principle. Conversion fee is calculated based on tax assessments. But then it did something completely different. It adopted conversion fee that was calculated based on completely different value. So that's exactly what happened in the Tidewater. Move to the next slide. And again, result is the decrease in BDA gross valuation by approximately 1.4 million. We can move to the next slide. The tribunal provided contradictory reasoning for its valuation of liabilities related to court proceedings. So again, specific item in BDA gross liabilities. And as you can see on this slide, this is again excerpt from the award. The tribunal stated that it valued BDA gross liabilities related to court proceedings based on BDA gross financial statements and the second Confinex valuation. But what we can see here is the actual valuation of these liabilities in these two documents. They say it's approximately not approximately, but exactly 50,000 dinars, so that's Serbian currency, which translates to approximately 417 euros. But what the tribunal did? The tribunal actually adopted the value of these liabilities at euro 200,000, thus contradicting its conclusion that these liabilities should be calculated based on second Confinex and BDA gross financial statements, as these provide significantly lower number. And as a consequence, the tribunal actually inflated the value of these liabilities, these court-related liabilities, by 199,583 euros. And this translates actually to 48,000%. So if the tribunal, so the number that the tribunal should have used if it followed its own conclusion that this number is based on, should be based on financial statements and Confinex, and the number it actually adopted is 48,000% higher than the number that the tribunal would have gotten if it followed its own conclusions.
What's the absolute number in comparison?
Yes.
What's the absolute number?
So that's a comparison between 417 euros, which comes from these two documents, and 200,000 that the tribunal adopted. Apologies. So next issue, the tribunal did not provide sufficient reasoning for its valuation of the capital gains tax. And as you can see on this slide, the tribunal merely stated that it adopted Mr. Kavan's calculation, so that's Serbia's expert, of the capital gains tax because it was quote-unquote objective and logical. However, the tribunal did not explain why it believed that was the case, or, and actually more importantly, it did not explain why it believed that the calculation provided by claimant's expert was not objective and logical. Once again, this contradiction or this lack of reasoning had significant impact because by adopting Mr. Kavan's calculation, the tribunal decreased BDA gross valuation by 2.6 million euros. And final point in my part of the presentation, the tribunal provided contradictory and insufficient reasons for its valuation of the total estimated liabilities. So as you can see on this slide, the tribunal first expressly stated that it calculated the amount of total estimated liabilities, and despite the, I should stress, despite the word total, this is actually just one item in liabilities. So it's not all liabilities, it's just one item. And the tribunal stated that these were calculated excluding deferred tax liabilities. However, once again, the tribunal then contradicted itself because the value that it adopted actually includes deferred tax liabilities. The value that it adopted is based again on second Confinex and BDA gross 2015 financial statements, increased for the Intesa debt. And as you can see on this slide, this number actually included 3.4 million of deferred tax liabilities. And you can see a reference there to specific part of Confinex valuation and financial statement, BDA gross financial statements, which include this number, this 3.4, which shouldn't be there, right? If you value it without deferred tax liabilities, it should not have been there.
3.1 million.
3.1 million, yeah. And the fact that the tribunal omitted, we don't know, the fact that the deferred tax liabilities are included actually also leads to double counting, because these deferred liabilities represent deferred capital gains tax. But the tribunal then concluded capital gains tax also as a separate item in the liabilities. So capital gains tax was now included twice. Once in the form of deferred tax liabilities, and second time as an individual item in valuation in BDA gross liabilities. And importantly, Dr. Hearn specifically pointed out to this point during the arbitration he had this point in his report. He explained the issue is there, so you cannot have the capital gains tax as a separate item. Once again, what the tribunal did, he just ignored Mr. Rand's explanation. And so, as you correctly pointed out, this one item, again, decreased the valuation by 3.1 million. And that brings me to the last slide in my part of the presentation. You heard many different numbers for many different items and their impact, so this is just a summary of that. And so you can see that issues with the tribunal's reasoning, or the impact of the leg of the reasoning, total impact of the leg of the reasoning related to valuation of BDA gross liabilities, is 12.4 million euros. Now, members of the committee, this is 85% of the total amount that was awarded to Mr. Rand in the arbitration. And that means that if the liabilities impacted by the tribunal's leg of reasoning were valued at the value proposed by claimants, rather than the value adopted by the tribunal, BDA gross valuation would have been almost double. And with that, members of the committee, I thank you for your attention, and with your leave, Mr. President, I'll pass the floor back to Mr. Pekas.
Mr. Pekas.
Thank you very much, Mr. Chairman. I will address the committee on the last two items of our presentation today. First, on the tribunal's manifest excess of powers by refusing to exercise jurisdiction over certain claims, and then at the very last part on the tribunal's decision on costs and the fact that it must be annulled as well if any other part of the award is annulled. So the two categories of claims where we state the tribunal exceeded its powers by refusing to exercise jurisdiction are first claims with respect to Mr. Rand's indirect shareholding in BD Agro, and second, claims relating to Mr. Rand's investment in the form of the loans to BD Agro. So with respect to the indirect shareholding, we submit that the tribunal departed from the definition of investment in the Canada-Serbia BIT and from established case law, which provides that there is no need to investigate whether the claimant satisfies conditions other than the ownership of shares. So first of all, we did not even put it on a slide, but it is undisputed that the BIT between Canada and Serbia defines investment as shares. This is probably the most intuitive form of an investment that one can imagine. Yet, the tribunal rejected jurisdiction over Mr. Rand's indirect shareholding on the grounds that Mr. Rand did not prove the existence of any contribution towards the acquisition of these shares. We submit that as a rule, share ownership constitutes an investment absent a risk of abuse or circumvention of the jurisdictional requirements, and it is not necessary to show contribution in such circumstances. And here we are not trying to reopen the debate about the Salini test, whether it should apply or should not apply. That debate has been ongoing for 25 years, and it undoubtedly will keep going until we all finish practicing. What is important here is that the Salini test was developed in a specific context. It was developed for the purposes of assessing whether rights under, in the original case it was a complex construction agreement, satisfied the definition of an investment or not. To apply the Salini test to something as straightforward as a shareholding is taking it too far. And obviously this is not just our proposition, there are ICSID tribunals which held so. The one tribunal to which we refer is the Lopez-Goin Family Trust and Others versus Republic of Nicaragua, which stated that there is no need to investigate how a shareholder acquired its interest in the entity holding the investment, or whether it satisfies additional conditions to the ownership of shares. And it then relates to some other decisions. Not all of them are ICSID, Saluka is UNCITRAL, but Pei Casado, Levi de Levi, RREEF and ICSID awards. And the levy actually award shows a bit why this discussion is sometimes taken to places where it does not belong, because the tribunal had a big problem to say that shares which were inherited are a protected investment and had to find some way how this satisfies the Salini test. We submit the right proposition would be to say that the Salini test should not be applied to share ownership. The tribunal's failure to give effect to the will of the parties, so Serbia and Canada, in the BIT, which stated that shares are an investment without any further requirements, constitutes a manifest access of powers, and here we refer to the decision in Malaysian historical Salvers versus Malaysia from 2009, where the Annulment Committee so held. In any event, this is not the only reason for the manifest access of powers. Another independent reason for the manifest access of powers with respect to this claim is the fact that the tribunal did not inquire about Mr. Rand's contribution, nor did it inform Mr. Rand that he needed to prove its existence. And here it is necessary to a little bit go back into how that issue became an issue. So the indirect investment is shares that Mr. Rand holds through MDH Serbia, a Serbian company. It was not disputed in the arbitration, A, that Mr. Rand is the 100% owner of MDH Serbia, and the tribunal so found in the award, and it was also not disputed that MDH Serbia owned the shares. Importantly, in the rejoinder, Serbia accepted that MDH Serbia had paid for the indirect shareholding. Here is a quote from paragraph 1028 of the rejoinder, and there Serbia says, since the owner of shares was Mr. Rand's Serbian company MDH Serbia, it can be inferred that it was MDH Serbia that paid for the acquisition of those shares. So it was undisputed that payment had taken place. It was also undisputed that the payment had been made by MDH Serbia. We submit that, therefore, it was also undisputed that Mr. Rand had indirectly paid for the indirect shareholding, because payments made by Mr. Rand's 100% owned company MDH Serbia are ipso facto indirect payments by Mr. Rand. This is the cornerstone of why investment law accepts indirect or investments. Serbia did not dispute that MDH Serbia had paid for the shareholding. They said they had no evidence of the amount, but they did not dispute the payment, the existence of the payment as such. And therefore, Mr. Rand had no reason to suspect that he needed to prove the existence of payments for the indirect shareholding. This is because even if we accepted that some contribution is needed, what is important is the existence of contribution, not whether the contribution is high or small. The threshold is actually contribution, yes or no. And the tribunal rejected jurisdiction over the indirect shareholding without ever inquiring with Mr. Rand about the payment for the shares made by MDH. So the tribunal never informed the parties that it would require evidence of the specific payments. Mr. Rand was a witness in the arbitration. He was examined at the hearing for approximately an hour and a half, both by Serbia's counsel and by all members of the tribunal. And yet, at no point was he asked by either Serbia or the tribunal about how he acquired the indirect shareholding and how much he paid for it. And we submit that it's not appropriate to then simply state in the award on an issue which appeared undisputed that Mr. Rand did not provide the required evidence. And then there is a third independent reason why the tribunal committed a manifest access of powers in connection with its decision. And this is that the tribunal recognized Mr. Rand's other contributions to his investment in BD Agro. And on this slide and a few other slides, I will just give you some examples. So the tribunal stated that Mr. Rand was appointed to BD Agro's board and exercised control over its operations. This included receiving financial reports and discussing BD Agro's financing needs with senior management, receiving reports, visiting BD Agro himself, communicating with external consultants and business partners. On the next slide, we can see how the tribunal agreed that Mr. Rand was always in full control of SEMBI, that was a Cypriot company through which his beneficial ownership was channeled, and continued to control BD Agro through SEMBI. The board of directors of SEMBI repeatedly discussed BD Agro matters, including issues such as progress on farm construction work and the status of BD Agro's herd and crops. It provided strategic decisions, including the sale of BD Agro's land. Then later in 2008, Mr. Rand paid 2.2 million euros directly to Canadian suppliers and vendors for the purchase and transport of heifers from Canada to BD Agro. He advised on BD Agro's management, etc. The tribunal listed these facts in connection with the other contributions which confirm the existence of an investment. The tribunal did so with respect to the beneficially owned shares over which it retained jurisdiction. But without giving any reason, the tribunal did not consider these additional contributions with respect to the indirect shareholding. And we submit that defies any logic. If I am an investor and I hold 75% through one channel, and then approximately 4% through another channel, and I act toward my investment, I control the investment, I manage the investment, I make all these intangible contributions, then these contributions are related to my investment as a whole. I'm not making any distinction between the shareholding I hold through one channel and the shareholding I hold through another channel. So if the tribunal was satisfied that these additional contributions were good enough to confirm, or actually to satisfy the contribution element of the Salini test with respect to the beneficial shareholding, it should have reached the same conclusion with respect to the indirect shareholding. So these are the three reasons. The third independent reason why the tribunal committed a manifest access of powers when refusing jurisdiction over the indirect shareholding. Now, the other category of claims which were rejected in a manifest access of powers is the loans. It is undisputed that Mr. Rand provided loans to BD Agro for the purchase and transport of BD Agro's new herd. That is actually what the tribunal, so if we can go back to slide 194, this is what we have there. The tribunal rightly concluded that in 2008, Mr. Rand paid 2.2 million euros directly to Canadian suppliers. So the invoices had been issued to BD Agro, but BD Agro didn't pay them, Mr. Rand did. If the owner pays something on behalf of the investment, this is just not the end of it. The investment then has to repay the money to the owner. This is a basic accounting principle. So the owner, here Mr. Rand, since that time has had a receivable against BD Agro. And that receivable was recognized, as Mr. Rand claimed, in the BD Agro's bankruptcy proceedings. What you can see here is an excerpt of a decision of the commercial court in Belgrade, which lists the determined and contested claims, and that claim was not even contested. That was accepted. Yes, BD Agro, as of today, still owes Mr. Rand 2.2 million euros for that payment. So what was the reason why the tribunal rejected jurisdiction? The BIT very specifically states that loans to an enterprise are a covered investment. This is letter D of Article 1 of the Canada-Serbia BIT. The tribunal, however, rejected its jurisdiction over the loans based on a carve-out from the protection of the Canada-Serbia BIT, which is set out in Articles 1K and 1L. And here, one thing is very important. If we go to the following slide, this is how the carve-out is defined in the treaty. If we go back to the previous slide, you can see that when the tribunal reprinted the carve-out, it made a change in the presentation which may change the meaning actually of the provision. What is important is the very last carve-out from the carve-out, which says that does not involve the kinds of interests set out in subparagraphs A to J. The way it's printed in the award looks like it may be related only to letter L, but if you look at how it's printed in the treaty itself, it is clear that it relates to both letters, K and L. So it's a carve-out from the entire carve-out. And this is very important because obviously we, or Mr. Rand, has the kind of interest set out in subparagraphs A to J. More specifically, it has the kind of interest set out in subparagraph D, which is a loan to an enterprise, a loan to BD Agro. So there is a carve-out from the carve-out. Even if the carve-out applied, the carve-out from the carve-out would apply as well, because the investment is properly characterized as an investment under Article 1D, and this cannot be trumped by the carve-out in letters K and L, as the very last sentence makes clear. And this analysis is confirmed by NAFTA case law, because we can observe very easily that the wording of the Canada-Serbia BIT is very much inspired by NAFTA. These are actually the same provisions sometimes. And obviously there are not so many cases rendered under the Canada-Serbia BIT, but there are many cases rendered under NAFTA. And these cases make quite clear that the carve-out only applies to mere cross-border trade interests. And an owner's loan to the investment obviously is not a trade interest.
Just for timekeeping, you have about 4 minutes left. Thank you.
And the carve-out does not apply also because Mr. Rand was the beneficial owner of BD Agro, and therefore he also held an interest as described in Article 1H. This is specifically stated in the award at paragraph 313. And so again, the carve-out from the carve-out would apply not only because there was a loan under 1D, but also because the provision of money was linked to Mr. Rand's ownership of BD Agro, which is Article 1H. Then the tribunal also declined jurisdiction over the loans under the ICSID Convention, again applying the Salini test, allegedly because they did not satisfy the duration requirement. So first of all, obviously the duration requirement is nowhere to be found in the ICSID Convention, but more importantly, the tribunal did not explain why the loans allegedly lacked the required duration, or even what the required duration was. And that is troubling, because the loans, most of them, were provided in 2008. So that was 7 years before the valuation date and a decade before the beginning of the arbitration. So to say that money that has been outstanding for such a long time lacks an element, the element of duration, requires some explanation, and none was provided by the tribunal. That concludes my submissions on the manifest access of powers, and now just very briefly the last part. We submit that the award on costs cannot survive the annulment, obviously, if the annulment is successful on the other grounds, or any of the other grounds, but because it is inextricably linked to other parts of the award that should be annulled. And here, what we have on the slides is just how obviously the tribunal tied its decision on costs on what it was deciding on jurisdiction and the merits and quantum. So if these elements move, if these elements change as a result of their annulment, so must the award on costs. So just for the sake of good order, here we also reprinted our request for relief. It is relatively complicated in the sense that we are asking for partial annulment, therefore we identify the specific parts of the award which we submit should be annulled. This is in line with how other annulment committees formulated their dispositives in cases of partial annulment. And with that, members of the committee, I thank you very much for your attention.
Okay, then we will stand up for lunch. We take 1 hour for that. Here.
Thank you.
Welcome back. We'll have the afternoon session commencing 5 minutes earlier. We'll invite Dr. Zelic.
Thank you, Mr. Chairman. We are
So they are sending soft copies to the office, okay.
Like in the morning session, we will have a short break in between. Yeah, just about 1.5 hours or something.
Thank you. I believe that we need the screens, which are not working for some reason. Yeah. So I
Let's
will
wait.
pause.
Yeah. Yeah. Okay. All good?
We
Can
are
you see
good?
the screen?
Yeah.
Please
Okay.
proceed.
Thank you. Mr. President, members of the committee, Serbia's opening statement will be divided in 3 parts. First, I will deal with the part of the annulment requests that concerns alleged lack of reasons for the tribunal's conclusions on quantum, and will specifically focus on the challenge dealing with PDAgro's assets. My colleague, Ms. Mihai, will then address challenges to the part of the award dealing with PDAgro's liabilities. And then finally, Professor Jundic will address the annulment requests that concerned the alleged manifest excess of powers by the tribunal and the decision on costs. Starting with the lack of reasons, I will not much elaborate on the standard for annulment on this ground, which has been by and large settled by practice. We have discussed this in our submissions, and you have, I believe, references on the screen. I will not bother you with the practice that you know quite well. But But let me just establish here that both applicant and respondent agree that the ground rule for annulment, due to the lack of reasons, was spelled out by the ad hoc committee in mine, requiring the award to enable, quote, one to follow how the tribunal proceeded from point A to point B and eventually to its conclusion, even if it made an error of fact or of law. End of quote. Applicant quotes this and calls the mine committee, quote, a leading authority on the issue, and we agree. As you know, the mine standard was further elaborated in subsequent practice, and the state of the law was described by Professor Schroer's commentary as, quote, merely requiring that the reasons enable the reader to understand what motivated the tribunal, end of quote. That is his commentary, CLA 206 at page 1349. Starting from this ground rule, and before addressing the specific challenges to the award, I will first outline the way the award dealt with the quantum, and especially with assets of BD Agro, the company that it found to have been expropriated. And we'll see whether the award provided the reasons that enabled the reader to understand what motivated the tribunal. Secondly, I will discuss the specific alleged challenges, then contradictory or insufficient reasoning, ignoring key evidence, and failure to provide any reasons for valuation of certain assets as alleged by the applicant. Moving to the award, in the damages part, the tribunal presented the parties' positions and then its analysis and conclusions regarding the specific issues relevant for the quantum, and you can see these issues on the screen. After finding a causal link between the treaty breaches and the injury for which compensation was sought, the tribunal proceeded to assess the amount of compensation. It first addressed the methodology for valuation. As you can see on the screen, the tribunal concurred with the experts' agreement on the valuation date being 21st October 2015. Then it found no reason not to follow the experts' approach to divide and value BD Agro's assets in two categories. One category was the core assets related to agriculture, which was the company's core business. And second category are non-core assets, primarily so-called construction land. Then the tribunal noted that the experts differed as to how to value core or farm assets. They disagreed on whether BD Agro was a going concern at the valuation date. Claimant's expert, Dr. Hearn, thought it was. Respondent's expert, Mr. Cohen, disagreed. The experts also disagreed on whether BD Agro should be valued in accordance with the discounted cash flow method, as Dr. Hearn did, or whether the company should be considered illiquid and valued on an asset basis, as Mr. Cohen did. Moving to the discussion of these issues, the tribunal mentioned prerequisite for applying the DCF method, primarily that the company must have a proven track record of profitability in order to be called a going concern. Then the tribunal quoted international valuation standards and their definition of a going concern, especially that the business enterprise is to be expected to continue operations in the foreseeable future. And then the tribunal mentioned that the BD Agro's creditors, by voting in favor of the company's reorganization, considered that the company would operate for the foreseeable future. And on the basis of this, the tribunal concluded that BD Agro was a going concern at the valuation date, as Dr. Hearn suggested. However, the tribunal also found that the BD Agro was, quote unquote, consistently loss-making in the period 2006-2014. So it was not such a exemplary story as applicant would like to present it, far from it. And then the tribunal said that, quote, in the absence of demonstrated profitability, end of quote, it did not consider it appropriate to apply the DCF methodology proposed by Dr. Hearn. Instead, the tribunal decided that the appropriate approach is to use the asset-based methodology. This method was also proposed by Mr. Cohen, as I mentioned. And this is a very important point that should be remembered, because the tribunal's adoption of the same method for valuation of all BD Agro's core assets as adopted by Mr. Cohen explained its later use of Mr. Cohen's valuation of these assets, and I will return to this point later. Then the tribunal moved to value BD Agro's non-core assets, that is primarily its construction land. It first established the size of the construction land, which was at the end agreed by the parties and is not subject to the present proceedings. And in the next step, it discussed the price per square meter of the construction land, which was a subject of considerable controversy between the parties, as you already know, I'm sure. The tribunal noticed the prices proposed by each of the parties' experts, and in short concluded that Mr. Cohen's approach, which was based on Mrs. Illich's land valuation, was more reasonable. Mrs. Illich is respondent's real estate expert. The tribunal explained this conclusion in a long paragraph, which I'm going to discuss now, and which discussed the prices proposed by claimant's expert, Dr. Hearn, and tested his sources, Dr. Hearn's sources of these prices against the views of real estate experts. Both the claimant's expert, one Mr. Grzesik, and another, obviously, expert was Mrs. Illich, that is our expert. And I will now summarize main points of the tribunal's analysis, so you can see that its reasoning is clear and easy to follow. And later on, I will address the criticism voiced by the applicant of these findings. As you by now know, Dr. Hearn proposed two prices for the construction land, for which he was also criticized by another of claimant's experts, by the way. Mr. Grzesik thought that there should be only one price. Anyways, Dr. Hearn proposed a lower bound price and the upper bound price. The tribunal first considered the lower bound price, which was 22 euros per square meter. And it noted that Dr. Hearn said that this price was based on valuations by Serbian tax authorities for the purpose of calculating the property taxes. At the same time, the tribunal noted Mr. Grzezik's, so claimant's, expert's conclusion that such valuations carry a little evidentiary weight. Then the tribunal noted that Dr. Hearn supported his lower bound price by the valuation from the December 2015 Confinex report. That's the first Confinex valuation. The tribunal also noted that the same Mr. Grzesik treated this valuation as only secondary evidence and did not rely on it because it did not refer to evidence of comparable transactions that were used for the valuation itself. And finally, the tribunal mentioned certain BD Agro's transactions, which Dr. Hearn also invoked, but noted that Mr. Grzesik disregarded them because they were too old relative to the valuation date and carried little evidentiary weight. So as you can see, the tribunal considered all sources that Dr. Hearn invoked in support of his lower bound price, but rejected them all with reference to the testimony of another claimant's expert, Dr. Grzesik, who specialized in real estate valuations. Then the tribunal moved to the upper bound price. And it noted that this price was based on Mr. Murgood's valuation. Mr. Murgood's evaluation is another evaluation which was commissioned by the company, by the BD Agro itself in 2014 in preparation of its reorganization. The tribunal noted that Mr. Grzesiek found this valuation, which was based on asking prices, by the way, it found that it flawed because it provided no information whatsoever about the sources of the asking prices and when they were published. Then the tribunal mentioned that the main source of evidence for Mr. Hearn's upper bound price was the value of the land in Batajnica. Batajnica is a township near Belgrade. And Dr. Hearn considered that this land was comparable to the construction land. The value of the Batajnica land was based on the so-called Batajnica transactions or Batajnica assessments, which were valuations prepared for the purpose of expropriations. And I will come back to that point later. The tribunal found three major differences between the Batajnica assessments and the construction land. And these three major differences led it to conclude that Batajnica assessments were an unsuitable comparator for the construction land. And these three major differences are the following. First, Batajnica assessments were based on valuation by the Serbian tax administration for determining the tax on property transfer. And as such, they were different from property valuations based on international standards. And this conclusion was supported by reference to the report of respondent's real estate expert, Mrs. Ilic. And I would ask you to recall that when I discussed lower bound price, you remember that the tribunal already rejected the main sources of Dr. Hearn's lower bound price on the same basis, because the valuations were prepared on the basis of the tax assessments by Serbian tax administration. Then the tribunal made a factual finding that the Batajnica assessments dated from March to August 2016. And on this basis, it concluded that they did not meet the requirement that the information used for valuation should originate on or before the valuation date. And this factual finding that you can see on the screen was supported by reference to Mr. Grzesiek's testimony, who testified that he was not sure when these assessments actually took place. The tribunal considered it, quote unquote, likely that the Batajnica's assessments were based on the tax administration's previous assessments that also took place in 2016. Considering the legal requirement that the Serbian tax administration had to base its assessments on its most recent tax decisions concerning real estate sales. And finally, the tribunal made a factual finding that there were several differences in the location and access to major traffic infrastructure between the Batajnica land and the construction land. And this finding was based on testimonies of Mrs. Ilic and Mr. Grzesiek, as well as on references to factual evidence. As you can see, the tribunal provided ample and logical reasons for its conclusion to reject Dr. Hearn's upper bound price for the construction land. Having rejected both the lower bound and upper bound prices proposed by Dr. Hearn, the tribunal accepted Mr. Cohen's approach, based on Mrs. Ilic's valuation, to be quote-unquote more reasonable, and consequently accepted the price he used to value the construction land. Having established the price of the construction land, the tribunal moved to discuss the price discounts applied by Mrs. Ilic and consequently Mr. Cohen, and there were two. First, there was a 10% adjustment to account for the willingness of the seller to negotiate the sale, and second, there was a further 30% discount. All in all, the tribunal found Mrs. Ilic's overall approach reasonable, as it said. The tribunal first found that the 10% discount reflected the usual practice in Serbia, and that claimants did not contest this. And this 10% discount is not subject to annulment. Then the tribunal moved on to discuss the 30% discount on the price of the construction land. And this part of the award, as you know, is subject to applicant's request for annulment. The tribunal considered whether the larger area of BD Agro's land should justify the discount, but it rejected this idea since, and I quote, BD Agro may have been able to split its land in smaller parcels before selling it, end of quote. That is paragraph 697 of the award. But then the tribunal continued the discussion by stating, quote, that there were other important differences between the comparators chosen by Mrs. Ilic and BD Agro's land. While the comparators had access to the road or other infrastructure, this was not the case for BD Agro's land, which still needed to be developed, end of quote. And on this basis, the tribunal concluded that, and I quote again, applying a discount appears reasonable, as any buyer would incur costs and spend time in developing BD Agro's land and would factor the development costs and time into the price offered, end of quote. As can be seen, the tribunal rejected the size of BD Agro's land as a basis for the 30% discount, but nevertheless accepted the discount on the basis that there were, quote-unquote, important differences in the development of the comparators and the construction land, particularly, quote, access to the road and other infrastructure, end of quote. Obviously, this is a factual finding, which was made in the award with reference to Mr. Grzezik's testimony, confirming the lack of development of the construction land, and also with reference to Exhibit RE 561, and that is from Mrs. Ilic's valuation, which contained advertisements for the comparators and their descriptions. The tribunal also noted claimant's criticism that it was not possible to establish the exact location of the comparators and determine the differences between two tracts of land. But it considered that, quote, the descriptions of the comparators make clear that they were equipped with infrastructure and had access to roads, end of quote. It then concluded that Mrs. Ilic's testimony that these differences justify a discount, quote, was not seriously rebutted, end of quote. And on the basis of this, and I repeat, factual finding, the tribunal concluded that applying a discount appears reasonable, because any buyer would factor the development costs in the price offered. And as can be seen, it is easy for a reader to follow this reasoning of the tribunal and to see why and exactly on the basis of which evidence it concluded that there were differences in the development between the comparators and the construction land owned by BD Agro, which, in the opinion of the tribunal, justified a discount. The tribunal then discussed the size of such discount and noted that there were no more precise indicators in the record about the size of the discount. And I should mention here that claimants and their experts provided no indications whatsoever about the size of the discount, while Mrs. Ilic applied the 30% discount. It was Mrs. Ilic's size of the discount that appeared reasonable to the tribunal, as the tribunal said, quote, failing more precise indications in the record. Again, it is quite easy to follow the reasoning of the tribunal, who looked into the record but found only Mrs. Ilic's suggestions as to the size of the discount. And these suggestions appeared reasonable to it. It is submitted that this is more than sufficient explanation for the tribunal's decision about the size of the discount, especially considering the wide discretion that tribunals have in the matters of quantum, which is especially so when the parties have provided insufficient evidence. And I will return to this point later on when discussing what the claimants had to say about this. And after this, the tribunal briefly discussed Mr. Cohen's bankruptcy sale discount, rejected it, and then dealt with BD Agro's liabilities, but this topic will be addressed by my colleague, Ms. Mihai. Now, let me jump further down the text of the award to paragraph 707, which you have seen today, where the tribunal outlined the final amounts of assets and liabilities and the net value of BD Agro on the valuation date. This paragraph starts by establishing an explicit connection with the preceding discussion. And I think this deserves a quote. It follows from the above that the tribunal has made several adjustments to the valuation prepared by the parties' experts, as a result of which the final amounts are as follows, end of quote. And then a table of BD Agro's assets and liabilities follows. And in the footnote 593 in this paragraph, the tribunal also stated that the table is based on the table in Kovan's expert report number 3, paragraph 4.4, after adjusting it as necessary in light of the tribunal's conclusions above, end of quote. So here again we see an explicit connection with the preceding discussion, and also information that the table in paragraph 707 is based on Mr. Kovan's table of BD Agro's assets and liabilities. And it's important to note that this table contains Mr. Kovan's valuation in a going concern scenario. And I will get back to this point later as well. Actually, I will say a few words now. Although you will remember that although the tribunal found that the company was a going concern, it nevertheless refused to use the DCF valuation suggested by Dr. Hearn, instead opting for the asset-based methodology used by Mr. Kovan. And that is at the award at paragraph 685 to 688 and paragraph 698. So the tribunal's use at paragraph 707 of the award of Mr. Kovan's table in a going concern scenario is therefore logical and clear and connects to the preceding paragraphs that I have just mentioned. As regards the assets, the tribunal followed the values in Mr. Kovan's table in a going concern scenario, except that the final calculation of the net asset value did not apply a 30% distress discount that Mr. Kovan applied in a going concern scenario. And this was in line with the tribunal's conclusion at the paragraph 701 of the award, so preceding the table, that the distress discount was inapplicable for several reasons, but I'm not going to go into these reasons because they are not relevant for the present case. But what is important is that there is explanation for avoiding the 30% distress discount. And obviously this 30% distress discount should not be confused with the 30% discount on prices in the valuation of the construction land. As can be seen, the tribunal's use of Mr. Kovan's valuation table is in accordance with its previous discussion on methodology. And the adjustments that the tribunal made are in line with its preceding discussion of the corresponding items. So we submit that after reading this part of the award, together with the preceding part of the award, it is clear how the tribunal went from point A to point B and then to its conclusion about the assets. And we submit that the requirement to provide reasons to the award has clearly been satisfied, and there is no justification whatsoever for annulment on this basis. As you have heard today, applicant considers otherwise, and I will now address applicant's challenges to the award. Applicant makes several allegations about contradictory reasoning in the award. One set of alleged contradictions involves contradictions between the tribunal's acceptance of Mrs. Illich's valuation of the construction land, which was based on asking prices, and its rejection of other sources, which were relied upon by claimant's experts. Another set of alleged contradictions concerns the 30% discount on the land price, and I will address these in turn. The first contradiction concerning sources of land valuation involves so-called Batenica assessments, and you have already heard about them. They were invoked by Dr. Heron and claimants. And let me say here and underline here that the Batenica assessments are not evidence of actual transactions, although they are sometimes referred to as Batenica transactions. These assessments were prepared for the purpose of expropriations, but there is no evidence on the record that actual transactions or actual expropriations took place. And on the screen, you can see Exhibit CE 888, on which previously claimants and now the applicant rely in the present context. But you can see on this in this exhibit that it does not provide any information indicating that actual transactions or expropriations took place. And in addition, you will recall that the tribunal found that valuations for the purpose of expropriation, which are based on property value assessments prepared by Serbian tax authorities, do not comply or do not conform with international valuation standards. So that's another reason why Batenica transactions were not acceptable for the tribunal. Now, applicant finds a contradiction in the fact that the tribunal, quote, rejected the Batenica transactions because they allegedly represented an unsuitable comparator, but accepted an asking price relied upon by Serbia from the very same area, end of quote. This is incorrect. The tribunal noted incompatibility of the specific land in Batenica municipality. And it is to this land, to the specific land, that it referred to as Batenica land or Batenica transactions. And you can see these specific land plots on the map. And you will note that this map, which was taken from claimant's expert, Mr. Grzezic's expert report at paragraph 6.17, this map or this photograph is different from the photographs that claimants showed you today. It's much more clear, and it shows that this is not the area, but rather specific land plots and specific transactions. And also, you can see that these specific land plots are located adjacent to the highway. I believe if you look a little bit closer, you can even see the cars on the highway, and are very close to the residential area of the township of Batenica. And you can see the residential area on the upper right-hand corner of the picture. Now, if you take a look at the advertisement for the land plot in Batenica, which provided one of the asking prices for Mrs. Illich's valuation, you will see that it mentions that the land plot is in the industrial zone of Batenica, not in the residential area, and that the land only has access for the paved road and it has infrastructure close to the plot. So it's clearly different from the land plots that you have just seen. This is also common sense. If the advertised land plot had been adjacent to the town and to the highway, similarly to the Batenica land, what seller would not have mentioned this fact? The distinction between the so-called Batenica land and the advertised land plot is obviously, and it's clear that there is no contradiction between the tribunal's rejection of the Batenica assessments and its acceptance of Mrs. Illich's valuation based in part on this one asking price for a land plot in Batenica. And finally, I should also mention here that the inclusion of a single asking price for the land near Batenica that you can see on this or on the previous slide, that the inclusion of this single asking price helped claimants receive more money because it raised the price of the construction land for over 17%. And the amount of damages that followed after the calculation was more than 7 million euros higher. Further, applicant uses the fact that the tribunal found that Batenica assessments post-dated the valuation date to create another alleged contradiction with the award by alleging that the tribunal used Mrs. Illich's valuation based on asking prices with unknown dates. And here, applicant refers to Mrs. Illich's indication that 2 out of 5 asking prices were from 2015. And you can see that on the page 145 of her report, where she provided the year but not specific dates. However, applicant fails to read Mrs. Illich's report as a whole. Among many references to the valuation date that you can see in the bottom part of the screen, Mrs. Illich also underlined the importance of the valuation date and expressly stated that she based her valuation on 21st October 2015 as the valuation date. And read together with this emphatic statement, Mrs. Illich's indication that 2 asking prices were from 2015 must be taken to mean that they were published before or on 21st October 2015. Now, there are 2 additional reasons why this alleged contradiction should not be taken up in the present proceedings. First, its underlying premise is that the tribunal was wrong in reading Mrs. Illich's report and in accepting Mrs. Illich's representation that the 2 asking prices originated before the valuation date. And as such, this concerns the tribunal's assessments of evidence. And as you well know, Arbitration Rule 34, paragraph 1, states that the tribunal is the judge of the probative value of the evidence produced. And the practice, here we quote the Tidewater Ad Hoc Committee, the practice is firmly on the position that an annulment committee should abstain from scrutinizing whether the tribunal established the facts correctly. The second reason why this alleged contradiction should not be entertained in the present proceeding is that applicant could have raised it in the arbitration but didn't. All along, the valuation date was not in dispute between the parties, and therefore it was open to claimants to argue that some asking prices used by Mrs. Illich might have post-dated the valuation date. So having failed to do so in the arbitration, applicant cannot raise this issue now in the annulment proceedings. Further, applicant finds contradiction in the fact that the tribunal refused to rely on the first Confinex valuation used by Dr. Hearn because it did not refer to evidence of comparable transactions. And at the same time, the tribunal relied on Mrs. Illich's valuation, although it also did not refer to evidence of comparable transactions. However, again, the alleged contradiction does not exist. The first Confinex valuation indeed relied upon comparable transactions, but did not provide any evidence whatsoever of such transactions. And this was pointed out by claimant's own expert, Mr. Grzesiek, who was quoted in the award, as you can see. In contrast to that, Mrs. Illich's valuation did not rely on comparable transactions at all. It relied, as you know, on asking prices. And asking prices are a legitimate source of information in land valuation, and their use is in accordance with international standards. Contrary to what claimants said today, and for their claim that asking prices are not in accordance with international valuation standards, they have provided no evidence whatsoever. What they did is to say that this is a source of valuation that has that may not be preferred when you have comparable transactions that are really comparable. But as Mrs. Illich and Mr. Grzesiek confirm, asking prices are use of asking prices is in accordance with international standards. Further contradiction is concerns Mr. Murgut's valuation. Applicant states that the tribunal accepted Mrs. Illich's valuation of the construction land but rejected Mr. Mergu's valuation used by Dr. Hearn, although both used asking prices as a sort of valuation. And again, I have to underline that the tribunal never took the position that any reliance on asking prices as a source of information in valuation is impermissible. Rather, it rejected Mr. Mergu's valuation, quote, because it provided no information about the sources of these prices or when they were published. So, in doing so, the tribunal quoted Mr. Grzezik's observation that, quote, if you are relying on asking prices, then as much information as possible is needed, end of quote. And mind you, this Mr. Grzezik's observation also confirms that asking prices are a valid source, because he himself says, if you are relying. He's not saying don't rely. He's saying, if you're relying, provide as much information as possible. And we submit that that Mrs. Illich's valuation, and that was accepted by the tribunal, did provide information about the sources and the time of their publication. Moving to the 30% discount. And here, according to applicant, the tribunal provided inadequate, insufficient, and contradictory reasons for applying a discount on the price of the construction land and for the size of the discount. You will recall that the tribunal, following Mrs. Illich, applied a 30% discount on the price of the construction land due to the fact that it was undeveloped and did not have access to roads and other infrastructure. So any buyer would factor the development costs into the price offered. Now, according to applicant, the tribunal provided two reasons for applying the discount. One reason related to differences in size between the land plots constituting the construction land and the comparators, and another reason related to their differences in access to infrastructure. We submit that this is inaccurate. The tribunal never based the discount on the differences between the size of land plots constituting the construction land and the comparators. On the contrary, it's clear from the text of the award that the tribunal refused to apply the discount on the basis of size, and I have already discussed that. The tribunal considered whether the large size of the construction land as a whole could justify the discount, and it found that it did not. And the tribunal's reasoning here is logical and easy to follow, and we have provided like virtually arguments per number. So first it noted that Dr. Hearn considered the large area of BD-Agro's land may have pushed the price down. Then, two, it considered that BD-Agro could split its land into smaller parcels before selling it. And three, concluded that the discount on the sale of the land as a whole was inapposite. Thereby, it refused to apply a discount on the basis of size. Obviously, applicant is wrong to say that the tribunal applied the discount on the basis of size of the land when the tribunal said that, that such discount is as a whole is inapposite, as you can see on the screen. After refusing to apply the discount based on size of the land, the tribunal found that there were other differences. It says, however, even if, can we go, sorry. However, even if it have done so, it remains that there were other differences. And these differences were the differences in infrastructure. And on this latter ground, it found that the discount was justified. Now, the applicant challenges the tribunal decision to apply this discount based on differences in infrastructure, but these are obviously factual matters. And this obviously concerns the tribunal's assessment of facts and evidence, which cannot be considered in annulment proceedings. And we have in detail discussed these factual issues in our submissions. I'm not going to bother you with that. It's on the slide. The references are there, if there is any interest for that. Applicant also argues that the tribunal provided insufficient reasons for the size of the discount, which was set at 30%. And there is one sentence about that in the award, which reads, quote, failing more precise indication in the record about the size of this deduction, it appears reasonable to the tribunal to accept the 30% discount applied by Mrs. Illich. For applicant, this is insufficient reasoning, and you have heard today mockery of this one sentence uttered by the tribunal. However, we submit that applicant here disregards the practice of ad hoc committees which adopted the position that for as long as a reader can follow and understand the reasoning of the award, it is irrelevant whether the reasoning is incorrect, inadequate, insufficient, whether it's one sentence or two sentences or three sentences. And the position of the practice has been summarized by Professor Schroer's commentary again, and you can see that on the screen. We submit that the steps in the tribunal's reasoning are clear, and the reasoning is easy to understand. And again, using the numbers. One, since there were no more precise indicators in the record about the size. Two, the tribunal applied Mrs. Illich's discount of 30%, because three, it appeared reasonable. And in this context, it is also important to recall that there is a general consensus that tribunals have wide discretion in the matters of quantum. And this is especially so when the record does not contain more detailed information about the relevant quantum issues, as in the present case. And you can see here the quote to that effect from the Vanna decision. Applicant disagrees and states that they and their expert allegedly argued that the size, argued about the size and stated that the size should be 0. However, what they did actually was constantly to argue against any discount, while they never provided any indication about a possible size of the discount in case it applied. They did that on their own peril, and now they should bear the consequences. So the only estimation of the size of the discount on the record before the tribunal was the 30% figure provided by Ms. Milic. And in such circumstances, the tribunal's discretion was wider, and it was indeed reasonable for the tribunal to accept her figure, as it explained in the award. Let me just say a couple of words about the alleged contradictions that applicant puts forward as a separate ground for annulment and formulates as contradiction between certain principles and Mrs. Illich's valuation. It calls these principles or findings on the appropriate valuation methodology, as we discussed in our submissions. These so-called findings on the appropriate valuation methodology or principles are in fact applicants' own summarizations and in large part are misrepresentations and oversimplifications of the award. And the applicant uses them to create artificial contradictions, and some of those we have seen, or many of those we have seen today. And in fact, these are mostly repetitions of his allegations that have been presented elsewhere and that I have just discussed. But we might return to that in the rebuttals. Now, another very important issue is applicants' allegations concerning the tribunal's alleged ignoring of key evidence in the award. There are three pieces of evidence allegedly ignored. The first two are easy, I would say. One is so-called Pazova transactions, and they were mentioned in Dr. Herr's report, but he used them only to confirm his upper bound price. And that was confirmed by claimants themselves at the hearing during the cross. And you can see on the screen what their counsel said during the cross. So once the tribunal rejected Dr. Herr's upper bound price as such, there was no reason to discuss its confirmation, the Pasova transaction themselves alone. So, and this is especially so as Mr. Grzesiek, their expert, also did not rely on the so-called Pasova transactions to set the land price. As far as the second Confinex valuation is concerned, neither the parties nor their expert relied on this document in valuing the construction land. And this is an obvious indication that the second Confinex valuation was not a key document in the context of land valuation, as applicant would like to present it now. Since this document has not been relied upon by the parties in this context, there was no reason for the tribunal to discuss it on its own when valuing the construction land. And moving on, we have the third piece of evidence that was allegedly ignored, and these are the two transactions that were identified but rejected by Mrs. Illich in the course of her valuation. Applicant complains that these two transactions were not, but should have been expressly addressed by the tribunal. And they, as you have heard today, concerned the land that was in the same municipality as the construction land. But Mrs. Illich did not consider them to be suitable comparators, since they concerned the land that was located, quote, near urbanized residential area, end of quote. So unlike the construction land, that was the land near urbanized residential area. It is also important to note that neither claimants nor their experts relied on these two transactions when valuing the construction land. Rather, they used them in order to challenge Mrs. Illich's valuation and also to broadly support their own valuations. Applicant's argument implies that the tribunal should have valued the construction land on its own by using these two transactions, because they were not the source of any of the parties' valuations. This would have been plainly absurd, as the tribunal was not capable of doing so on its own and was not even so requested by claimants in the arbitration. Now, applicant uses a lot of space to argue that these transactions were highly relevant and that Mrs. Illich was wrong to disregard them because she allegedly admitted at the hearing that there were in fact no residential buildings next to the land in question. This is not accurate. Here you have on the left-hand side of the screen, you can see what Mrs. Illich said at the hearing and how she explained that this land is actually in the residential area. And you can also see the same thing from the photograph on the screen, which clearly shows that both transactions are in the urbanized area, as Mrs. Illich Illich testified. And you can see the houses, these little dots or stripes that are near the roads, and you can see that they are everywhere around both transactions. And in any case, this question concerns assessment of facts, and this assessment cannot be raised in the annulment proceedings, and the correctness of this assessment. Another issue.
Just pausing
Sorry?
for my benefit. Go back to the last slide again.
Yes, sure. Go to the
one
one
with
with
the
the photograph.
Yeah.
Can we go to the one with, yes.
So is it my understanding that A is the 33 euro per square meter property and C is the 22 per square kilometer property?
I'm not sure at the moment. I will have to check.
So because you put A and C there, how do they relate to the one that the claimant have put up earlier?
I think that we can, that this is just...
We need an orientation for this, otherwise I'm not sure. Because based on this, I seem to get the impression, and on the left, further beyond the picture will be the construction land. Is that my understanding wrong or correct?
Yes, you're right. It would be left we can supply another. I think that the claimant's PowerPoint today had a wider
Correct.
picture. On the left of the transaction C is the construction land. It is a huge area, 279 hectares. And you see on the bottom left corner, you see the farm. This is, I think that this is the big, somewhere there is the beginning of the farm, if I'm not mistaken. But the farm, and this is something that should also be explained, the farmland is very small part of the construction land, as we call it, or the zones A, B, C land, which, as I said, is 279 hectares. So this is on the left-hand side of the screen.
Okay.
But the issue here was whether these two transactions were compatible because they were in nearby or in the urbanized area of the town of Dobanovci. And Ms. Silic testified that they were.
Thank you.
So I would like to now go to another issue, which is whether the tribunal was supposed to deal with these two transactions directly and expressly, or was it sufficient that it dealt with them implicitly by accepting Mrs. Ilic's valuation and consequently by accepting her disregard of the two transactions? And I would here also like to recall a well-established practice of ad hoc committees holding that motivation for an award may be provided, not only expressly, but also implicitly, either by inference from the express terms or by reference to evidence. And I think this is fairly settled, although claimants today would like you to believe that probably most of the decisions of the ad hoc committees annulled the tribunal's awards. That's the one point, the impression that they wanted to create. And another impression is that that the tribunals have to deal with issues directly and expressly. I would say that the practice, and you know that well, that the practice clearly supports the position that that implicit dealing with issues and by inference from the express terms of the award or by reference to evidence is sufficient. And this is this is just I would say a part of the practice. Now, in paragraphs 692 to 693 of the award, the tribunal accepted as reasonable Mr. Cohen's valuation of the construction land, which was based on Mrs. Ilic's valuation. You know that. Mrs. Ilic explicitly excluded the two transactions in question from her valuation. By expressly accepting Mr. Cohen's and Mrs. Ilic's valuation, the tribunal implicitly accepted Mrs. Ilic's finding on the two transactions and that they were not comparable to the construction land and that they should be disregarded in the valuation. In this context, applicant invokes TECO v. Guatemala to argue that the tribunal was nevertheless required to address the transactions in questions simply because they were in applicant's view, and only in applicant's view, highly relevant evidence. However, I think that TECO can be distinguished from the present case on two grounds. First, in TECO, the tribunal found that there was no sufficient evidence or no evidence at all on the record to calculate the transaction price for the purpose of calculating damages. Although at the same time the record contained expert reports and other relevant information that the tribunal ignored in TECO. In contrast to this, the tribunal in the present case did not ignore expert reports. Rather, it accepted Mrs. Ilic's valuation of the land, which also rejected the two transactions now invoked by applicant. So this is the first difference. Another difference is that the rationale of the decision in TECO was not based on just any failure to address relevant or key evidence, but the tribunal's failure to address the relevant evidence while stating that there is no such evidence on the record, which made it impossible to follow the line of thinking, the reasoning of the tribunal. In other words, if one is able to follow the reasoning of the tribunal, as one is in the present case, the fact that the tribunal might not have addressed certain evidence is insufficient to lead to annulment in our submission. Moving on to the applicant's argument that the tribunal did not provide any reasoning with respect to its valuation of BD Agro's assets other than the construction land. As I said, the tribunal provides its valuation of BD Agro and its assets in a table reproduced in paragraph 707 of the award. And this table is preceded by the sentence referring to the above discussion that the tribunal had in the award, and that the tribunal made several adjustments to the valuation on the basis of this discussion. And there is a footnote explaining that the tribunal based its table on Mr. Cohen's third expert report, after adjusting it as necessary in light of the tribunal's conclusions above. Now, the applicant argues that the tribunal did not provide an explanation as to why it opted for Mr. Cohen's instead of Dr. Hearn's valuation. This is not true. As I discussed when outlining the reasoning of the award, the tribunal rejected Dr. Hearn's use of DCF method and opted for an asset-based methodology. And this methodology was also used by Mr. Cohen in valuing the farm assets, all farm assets. And so this is why the tribunal's valuation of BD Agro's assets other than land was based on Mr. Cohen's valuation of these assets. And this clearly follows from the tribunal's discussion at paragraph 687 to 688 of the award. So we submit that the tribunal's reasoning follows from these premises. The premises are there in 687 to 688, and it follows down to 707. Now, the tribunal alleges two instances in which the applicant alleges two instances in which the tribunal did not provide any reasoning about its valuation of specific assets. First, the Novi Bečej castle and the land. The question is, whether the tribunal and Mr. Cohen included in the valuation both the castle and the land, and why they put the price or the value of 0.2 million euros on the item Novi Bečej. Now, applicant has failed to know that the tribunal accepted Mr. Cohen's valuation, and Mr. Cohen's valuation separately valued the castle and the land in Novi Bečej. The valuation of the land, which was based on Mrs. Ilić's valuation, valued the land. And it is undisputable that Mrs. Ilić did not value the castle. So the land was valued at 0.2 million, and it's in the table specifically stated as Novi Bečej land. Then Mr. Cohen's valuation of BD Agro's other assets, which was based on the second Confinex valuation, specifically included the second Confinex evaluation, specifically including the Novi Bečej castle among, quote, other fixed assets. And there are references on the screen to that effect. I'm not going to bother you with that, but you can go and see that. So the land was valued by Mrs. Ilić, the castle was valued by second Confinex and then by Mr. Cohen and accepted by the tribunal. So by reading the award and by reading Mr. Cohen's expert report, one can clearly see and understand the tribunal's motives behind separate valuations of the Novi Bečej land and the castle. Second, applicant argues that the tribunal did not provide any reasoning for his decision to value BD Agro's current assets at 5 million euros, nor did it explain which assets it included in the mentioned category. And this is again inaccurate because, as I said, the tribunal adopted Mr. Cohen's valuation of BD Agro's assets, including the current assets, on the basis of the analysis that I have just outlined. Applicant also argues that the tribunal should not have followed Mr. Cohen's valuation of assets other than land because it was based on the second Confinex valuation, which was after the valuation date. And this is an argument that the claimants make and that will be dealt with by my colleague, Mrs. Mihai. I will just shortly say that what is relevant is not the date of the document, but the date of information used in valuation. And a willing buyer would act prudently and with due diligence and would have been familiar with the BD Agro's financial information that was in BD Agro's books. It was only later on or shortly onwards summarized in its financial statements used by the second Confinex valuation. Now, again, applicant is precluded from making this argument because the second Confinex valuation was never challenged by claimants in the arbitration on the basis that its information originated after the valuation date. On the contrary, they considered it quote-unquote credible and tried to impose it upon respondent in the arbitration. So, to sum up, applicant's argument that the tribunal did not provide any reasons for its valuation of BD Agro's remaining assets other than the construction land is without merit. The tribunal explained its choice of the valuation method, which corresponded to Mr. Cohen's valuation method, then used his table of BD Agro's assets and liabilities in the valuation while making certain adjustments to it. In conclusion, all applicants' arguments concerning the alleged lack of reasons in the award regarding the value of the company's assets are completely without merit in our submission and should be rejected. And thank you for bearing with me, and I'll give the floor to my colleague, Mrs. Mihai. Thank you.
Good afternoon to everyone. I will continue with addressing claimants' arguments related to BD Agro's liabilities. But before I address each of 5 specific categories of BD Agro's liabilities that, according to applicants, are reasons for annulment of the award, I would like first to shortly address the question what actually the tribunal stated in paragraph 693, third bullet point 2 of the award. So as we can see the whole paragraph copied on the screen together with the footnote. And I will only read the first sentence, which says that it is well accepted that the information used for valuation should originate on or before the valuation date. So this sentence is interpreted in this proceeding by the applicant as it is read like that the tribunal wanted to say that all documents post-dating the valuation date should be excluded from valuation assessment. So back to this paragraph, I think that simple, quick reading of this paragraph together with the footnote can answer the question whether applicant's interpretation is correct or not. And I think that it is obvious that it is not correct. Because first of all, tribunals refer explicitly to information and not to documents. And then if we read the whole argument of the tribunal, which is presented in this paragraph, we will see why the tribunal didn't accept some Bajtanic assessment that were used by Mr. Gershik. And the tribunal here explained that when Mr. Gershik was asked, do you know the actual time of the transactions that they used for their assessment, that the answer was no. So what was actually important for the tribunal was the time of the assessment, of the transactions, and not the time of the document when these transactions are presented. And that document is also referred to in footnote 558, and this is, no, sorry, it is not in that footnote, but it is referred in footnote 557, and that is document CE 159, that is tax administration Zemun branch document, where all these Batenitz assessments were presented. But the question, which was important for the tribunal, were when those transactions occurred, whether it was before or post-valuation date. So in their reply, the applicant tried to present three far-fetched arguments to explain that the tribunal meant to say documents and not information in the quoted sentence of the paragraph 669. And the first applicant's argument is that Ms. Ilic, which is respondent expert, also criticized claimant expert for using the documents that post-date the valuation date. However, that is completely wrong. Ms. Ilic never do that. On the contrary, she did criticize claimant's expert, but because of use of information dated after the date of valuation, as you can see on the screen, and also you can see on the screen the references to Ms. Ilic's first report and second report, where she criticized claimant's expert due to use of information, not documents that post-dated valuation date. Second applicant's argument relates to tribunal's conclusion from paragraph 690, second bullet point, where the tribunal explained how it came to the conclusion and why it disagreed with the respondent that some land plots that were the subject of the court proceedings should be excluded from the valuation of BD Agros assets. And there the tribunal said that it sees no reasons to disregard the legal situation as it stood at the time of the valuation, being that the land in question was owned by BD Agro. And I would say that actually in this instance as well, the tribunal followed its stance that the information used for valuation should originate on or before the valuation date, and that is why it rejected to disregard the legal situation as it stood at the time of valuation. Third applicant's argument is that according to the applicant, tribunal's intention was to exclude post-valuation date documents, and to prove this allegation, they say that the tribunal accepted the use of the fair market value methodology to calculate the value of BD Agro assets on the valuation date, which is correct. But from that, they conclude that since the fair market value method requires the parties to act based on information available to them, the tribunal must have wanted to disregard post-valuation date documents that contain pre-valuation date information, because such documents were not available to a willing buyer at the valuation date. That is, of course, incorrect argument. Why? Because second Confinex report and BD Agro's financial statements only record financial state of the BD Agro. They do not change it. So all information that are contained on that document already existed. So they were available even before these two documents were created. So date of creation of this document does not have anything to do with the fact whether the information contained in the document were available to a willing buyer or seller. And I will now continue with addressing applicants' annulment arguments concerning the tribunal's reasoning related to valuation of 5 BD Agros liabilities. And these are total estimated liabilities court proceedings liabilities, redundancy payments, conversion fee, and capital gain tax. So I will start with the total estimated liabilities. And this item is analyzed, and we can see on the screen in paragraph 699.1 of the award. And what should be noted first is that the tribunal expressly stated that here it analyzed total estimated liabilities excluding deferred tax liabilities. As what is also evident from this paragraph of the award is that Mr. Cowan and Dr. Hearn agreed that BD-Agro's estimated liabilities are relevant for the valuation of BD-Agro assets, and what they disagreed on is the amount of these liabilities. And the award mentions that Mr. Cowan submitted that BD-Agro estimated liabilities were 42.2 million euros, while Dr. Hearn reaches a lower amount of 37.8 million. And what the tribunal had to do is to decide which amount should be accepted. And in doing so, the tribunal noted several facts. First, the tribunal noted that the second confidence valuation determined BD-Agro's liabilities in the amount that is higher than the one calculated by Dr. Hearn. Then it noted that BD-Agro's financial statements use the same amount as the second confidence valuation as a basis for liability values, and which, as I mentioned already, which amount is, as I mentioned, higher than the Dr. Hearn's amount. Further, tribunal noted that Mr. Cowan relied on the second confidence valuation and his own analysis, and that he added 1.8 million to the amount indicated in the second confidence valuation because it was explained why, and that is because the principal amount of Banca Intesa debt accounted for in the second confidence valuation increased, resulting also in an increase of the default interest payable thereon. And after establishing all these facts, the tribunal adopted Mr. Cowan's approach. Why? Because the tribunal found that Mr. Cowan's approach is reasonable. Applicant disagrees and argues that tribunal's reasoning is both contradictory and insufficient. So let me now address why applicant argues that this reasoning is contradictory. So according to applicant, the tribunal's reasoning is contradictory first because the tribunal established that it would not rely on post-valuation date documents, and then in this paragraph of the award, it actually did mention second confidence valuation and BD-Agro's financial statements. However, as I already mentioned, the tribunal never said that it will disregard post-valuation date documents. And what is also important is that the claimants themselves, but also their experts, also considered second confidence report and BD-Agro's financial statements as a credible source for the financial information related to BD-Agro. So it is now hard to understand how can dispute the use of these documents by the tribunal. And also, if I can address one more thing, here in this paragraph that relates to total estimated liabilities, we also have one footnote but that concerns another argument of claimant, and that is Banca Intesa claim. So applicant argues that tribunal's reasoning related to the total estimated liabilities is also contradictory because it accepted Mr. Kovan's calculation of the default interest on Banca Intesa claim, although that calculation is based on both evidence and information post-dating the valuation date. And these allegations are again wrong, since none of the information used for calculation post-date valuation date, and actually that can be easily concluded from the document referred to by the tribunal in the award. In particular, in the footnote 577, when explaining total estimated liabilities, the court referred to the exhibit RE646, and that is Agrunia's registration of claim with enclosures. And what can be concluded from that document referred to by the tribunal is, first, that BD Agro's debt towards Banca Intesa was the subject of the court proceedings before the valuation date, and not only that it was the subject of the court proceedings, but the final court judgment was rendered before the valuation date. Second, the amount of 1.48 million used by Mr. Kovan in his third expert report as the principal amount for the calculation of the default interest is the amount that was copied from the final court decision that was rendered before the valuation date. So the principal amount is also predating the valuation date. And third, Mr. Kovan used the default interest rate applicable in the period from 2013 until the devaluation date. That can be also concluded, and not concluded, but that is evident from calculation presented in Mr. Kovan's third report in para 2.22. And fourth, Mr. Kovan calculated the default interest until the valuation date. So all information related to calculation of the interest on Banca Intesa debt predate valuation date, and importantly, the tribunal had referred to Mr. Kovan's calculation and also to the document which is factual exhibit presented in the arbitration proceedings, showing that all these information predate valuation date. I will now turn to applicant's argument that tribunal's reasoning related to valuation of the total estimated liabilities is insufficient, and according to applicant, it is insufficient because it is allegedly unclear whether tribunal's final calculation of the total estimated liabilities includes deferred tax liabilities or not. And according to applicant, if final calculation of the deferred tax liabilities is included in the total estimated liabilities, then it would mean that it is that the tribunal made double counting, because the tribunal have capital gain tax as a separate point addressed in relation to BD Agro's liabilities. However, what is important to note here is first that this particular argument that Mr. Kovan has double counted capital gain tax, one time as a separate item and another as the part of the total estimated liabilities, was actually raised by claimant's expert, Dr. Kern, during the arbitration proceeding. And after it was raised, Mr. Kovan actually addressed that. And not only that he addressed that, he agreed with Dr. Herr and he corrected his calculation in his second expert report in paras that you can see on the screen. Even more important is that after this second expert report of Mr. Coven, claimants and their expert never raised that as an issue. So Dr. Herr had another report, third report. Dr. Herr was filed after Mr. Coven's second report. We had a hearing after that. And no one raised an issue of double counting ever again. So having in mind that claimants raised no objections after Mr. Coven's corrected calculation, there was no reason for the tribunal to separately address that question in the award. And one more point that is, of course, important, because claimant's argument is that it is unclear whether the tribunal's final calculation of the total estimated liabilities includes deferred tax liabilities, is that in para 699.1 of the award, tribunal expressly stated that in that paragraph it analyzed total estimated liabilities excluding deferred tax liabilities, and that it arrived to the amount of euro 42.2 million for this category. And then the same is also stated in paragraph 669 of the award, and then again in paragraph 707. So there are two paragraphs of the award from which we can conclude that the calculation of the total estimated liabilities in the award does not include deferred tax liabilities. I will now shortly address court proceedings liabilities. And in paras 653 and 669 of the award, the tribunal rightly noted that the parties' experts had disagreed regarding the inclusion of the court proceedings liabilities in the overall liability assessments of BD Agro. And unlike Dr. Herr, Mr. Coven was of the opinion that these liabilities amounts to euro 200,000, and that they should be accounted for, and explained that his calculation consisted of liabilities for which he believed were probable at the valuation date. And you will see that in footnote 584, the tribunal actually referred to Mr. Coven's third expert report, where Mr. Coven explained why this amount was included, why this item and this amount, why they were included in his calculation. And what the applicant misrepresents the award and states that the tribunal accepted Mr. Coven's estimate, Mr. Coven's amount of the court proceedings liabilities, and that when doing so, the tribunal stated that it accepted the amount because the same amount was also indicated in BD Agro's financial statements, which is incorrect. Tribunal never said that. What tribunal said is that it agrees with Mr. Coven's inclusion of court liabilities because the item was included in BD Agro's financial statements. So actually what the tribunal recognized is that court proceedings liabilities as a categories are also recognized as relevant in financial statements, and then decided to include it, but accepted Mr. Kovan's calculation of this category of the liabilities. Let now move on redundancy payments.
How long will you be on this topic? Because if you
I
like,
think that
we
in
can
10
continue.
minutes or 15 max, I will finish.
Right, because you only have about 35 minutes more
35, yeah.
for the rest
I will
of
be
you.
done in 10 or 15.
Okay, so you want to continue? We
And
can
then,
continue.
and then Professor Jundic will continue. Yeah.
So 10 minutes and we'll stop for a while, is it? Or we want to go straight through?
Or well, I think that maybe we should take a pause after I finish.
Okay, good. Carry on.
Thank you. So the parties had different opinions with respect to redundancy payments as well, and they disagreed whether these payments were mandatory or not, and whether they should be accounted for in calculation of BDAGRO's liabilities. So in para 699.6 of the award, the tribunal noted that while arguing that these payments were only voluntary, claimants offered no authority in support of their assertions. And for the tribunal, as you can see for this paragraph, which you can see on the screen, for the tribunal, actually that was the main reason to conclude that these payments were mandatory and that thus must be accounted for. And you will see that the tribunal continued with its explanation, saying that in any event, BDAGROS was obliged to prepare redundancy program in accordance with Annex 1 of the privatization agreement. And further, BDAGROS financial statements also recognize redundancy payments as being obligatory. For applicant, this reasoning is contradictory because such decision cannot stand with tribunal's conclusion that the privatization agreement ceased to apply in 2011. However, these insertions are baseless because the tribunal referred to the obligation, as we saw from the quotation. Tribunal referred to the obligation to prepare redundancy program under the Annex 1 of the privatization agreement only as in any event consideration, and nothing in tribunal's reasoning actually suggests that its decision related to redundancy payments would be any different without mentioning privatization agreement in his reasoning. Applicant further argues that the tribunal made a mistake when it concluded that BDAGRO's financial statements recognize redundancy payments as obligatory. However, as can be seen from the award itself, and that is footnote 588, that is not true, and notes to financial statements indeed state that BDAGROS was obliged to make redundancy payments, and these notes are indeed quoted in the award in the footnote that I have mentioned. The tribunal quoted the notes of the financial statements, and that is CE 171. And finally, for the sake of completeness, I have to say that claimants indeed and their expert indeed failed to support their conclusion that redundancy payments are not mandatory. And you will see that from Dr. Hen's report, there is no authority to support his conclusion. And unlike, for example, Mr. Kovan, respondent's expert, who supported his conclusion that redundancy payments are mandatory by referring to labor law and also some reports that dealt with that question. So the tribunal was right to conclude that Mr. Kovan's calculation and is correct one. And finally, conversion fee. I will address it shortly. So it is elaborated again in para 699.2 of the award. And here you will see that the tribunal provided detailed explanation for its decision. So first, it noted that the parties' experts agreed that the development of Bidiagros land necessitated its conversion from agricultural to industrial use, and that it had to pay some conversion fee. And then tribunal also noted that the experts agreed that the fee should be calculated as of 50% of the average price of agricultural land. They disagree over the final amount of that fee. So in deciding which calculation to adopt, the tribunal noted that Ms. Ilic provided detailed justification of her approach, including clear reasoning as to why the previous year's tax method should be applied. And here it is maybe useful to pay attention to, again, footnotes of the award. So you will see that, first of all, the tribunal in the footnote 578 referred to Ms. Ilic's report, Appendix 1.1. And you will see in that appendix, Ms. Ilic explained really in detail why this method should be, why it is important, to apply previous year's tax method. And Ms. Ilic explained that by referring to legislation, to Serbian legislation. And just to know that Dr. Hern didn't apply it. So actually, Dr. Hern's calculation was not in accordance with Serbian law. Because according to Serbian law, you have to apply previous year's tax method. And then you will see again footnote 580 and 581, and there the tribunal referred to transcripts from the hearing. And if you look at those transcripts, you will see that indeed at the hearing, Ms. Ilic really explained again in detail, answering the question of the presiding arbitrator, why she applied previous tax year method. And you will see in a quote, in a footnote 581, and there you have a quote from the hearing of Ms. Ilic. And you will see that at the end of the quote, Ms. Ilic mentioned the price of 3.4 euro is the price of agricultural rate in the zone, etc. But that amount, as we had a chance to see, that price of the land, as we had a chance to see, it was also mentioned in claimants' today's presentation. And they say what they say. They say, so how comes these 3.4 euros per meter quad? So it's not, we do not understand that, and the tribunal didn't explain that. But what is the problem with that argument? Claimants never contested that amount during the arbitration proceeding. So Ms. Ilic addressed that in detail in her expert report, and then again Ms. Ilic mentioned that at the hearing, and mentioned this estimate, that price for the land, but claimants and their expert never stated, never mentioned, never disputed that this amount actually do not correspond to the previous year's tax method. And however, they expect that the tribunal should have elaborated on that. Well, hardly that they can be right. I only have to address really shortly capital gain tax. So related to the valuation of the capital gain tax, and that is point 5 in the paragraph 699 of the award, the tribunal compared the approach of the parties' experts, and in doing so, it noted that Dr. Hens calculated this tax by using deferred tax liabilities from BD Agro's balance sheet as a proxy, and here is the important point. Why? Well, based on claimant's instructions. And really, if you go to see Dr. Hens' report, you will see that there are several assumptions that was presented to him by claimants. And Dr. Hen just accepted those assumptions and made calculation. Unlike Dr. Hen, Mr. Coven provided his own calculation. And he explained how he came to that, to the amount of the capital gain tax. And what the tribunal did, the tribunal said, well, I accept Mr. Coven's calculation because for me it is objective and logical. And what is objective and logical? Well, the explanation provided by Mr. Coven. And the applicant alleges that the tribunal decision in this regard is not sufficiently detailed, and that as such it prevents the reader from following and understanding the tribunal's conclusion. However, as I mentioned already, it was tribunal assessment that Mr. Coven's approach is both objective and logical, and whether the tribunal was indeed right and whether Mr. Coven's approach was indeed objective and logical in comparison to Dr. Hen is immaterial for the annulment, and that is confirmed in several annulment cases. And with this, I will conclude my part of the opening statements. Thank you.
So we'll take a short break. Let's keep it at 20 minutes. Okay.
The applicant's request for annulment of the decision on costs. A manifest excess of powers under the ICSID Convention is an excess of powers that is simultaneously self-evident, that is evident on a first reading of the decision without need for further investigation or inquiry, and substantially serious, meaning that it must be outcome determinative.
Can you raise your voice a little?
Yep. Sorry. In order to commit a manifest excess of powers, a tribunal must reach a decision that is untenable, unreasonable, or in other words, indefensible. I believe there is no disagreement between the parties that annulment is not an appeal against the award, and that the award cannot be annulled simply because the committee holds that the tribunal erred in its application of law. So the simple error on the side of the tribunal is not enough. In order to succeed with his request, the applicant must demonstrate that the tribunal, by refusing jurisdiction, went against the principle of law that is so monolithic or so firmly established that it is not subject to debate, or that it committed an error so gross or so egregious that no reasonable person could accept it. Now, this is a very steep hill to climb for applicant, and it is clear we submit that he failed in doing so. Now, the applicant's request is essentially an appeal against what Mr. Rand sees as wrong interpretation of the convention, and to a certain extent the Canada-Serbia VIT. The tribunal refused jurisdiction primarily since both the indirect shareholding and the payments for the benefit of BD Agro lacked certain requirements of an investment under the ICSID Convention. In the award, the tribunal accepted a well-known and widespread interpretation of Article 25.1 of the ICSID Convention, in accordance with the ordinary meaning of the term investment. That is, that investment has an inherent objective meaning comprising three characteristics: commitment of capital or other resources, a certain duration, and risk. Applicant's response is to say that the investment under the convention has no meaning. That is, that the only relevant definition of an investment is given in Article 1 of the Canada-Serbia BIT. Now, there is no need to explain again in detail that most of ICSID tribunals have applied the so-called double barrel test, or that the three objective criteria test is also well established in defining the notion of investment. It suffices to say that the applicant failed to explain precisely how the tribunal, by applying the majority position in ICSID practice, committed a manifest excess of powers. Mr. Rand, of course, can consider the tribunal's interpretation wrong, and even you, members of the committee, might agree with such opinion. However, the tribunal certainly did not make an error which is so gross or so egregious that no reasonable person could accept it. This alone renders the applicant's request unsustainable from the onset. With respect to the indirect shareholding, the tribunal refused to entertain applicant's claim about the indirect shareholding simply because Mr. Rand failed to demonstrate that he made any contribution in obtaining the shares. The tribunal started by stating the obvious. This is the award, paragraph 271. It was up to claimants to prove their contribution, and that the mere ownership of assets without proven allocation of resources is not enough to establish jurisdiction under the convention. It concluded that claimants did not meet their burden of proof, since they failed to submit any evidence whatsoever that Mr. Rand actually paid 200,000 euro for the indirect shareholding. An applicant's attack on the tribunal's decision is based on two main arguments. First, the applicant argues that the tribunal was wrong to examine whether he made an actual contribution of resources. You have heard today again that Mr. Rand claims that it is established case law that the ownership of shares is enough for a tribunal to accept jurisdiction without any further requirements or conditions. Of course, this is not the established case law. In fact, the exact opposite is true. There is a considerable number of decisions, some of which were relied on by the tribunal itself in the award, holding that a tribunal must decline jurisdiction. An ICSID tribunal must decline jurisdiction if the ownership of shares is not coupled with commitment of capital. Even awards relied on by applicant in reality demonstrate that there is no investment without proven contribution made, at least initially. This is in particular the case with award in Lopez Goinevi, Nicaragua. In fact, it was explained in respondent's submission. This is all to say, members of the committee, that the tribunal reached a correct decision. Ultimately, however, it does not matter whether the tribunal was right or wrong, because simply there is no legal standard, there is no perspective so favorable for applicant under which the tribunal's decision could be considered as untenable or unreasonable. Second, applicant argues that the tribunal erred in its valuation of evidence. According to Mr. Rand, since the majority of the tribunal accepted certain expenditures as proof that he acquired the so-called beneficially owned shares of BD Agro in the privatization process, the very same evidence of contribution should have been used by the tribunal to justify the acquisition of the 3.9 nominal ownership by his Serbian company, MDH Serbia. Now, it is important to note that claimants never made such argument during the arbitration. It is also important to say that such indicia of beneficial ownership are entirely inappropriate when it comes to the acquisition of nominal ownership. This was the fact that was explained in some detail in our written submissions. The most important thing here, however, is that as a matter of principle, a committee cannot engage into reevaluation of evidence that were used in the original proceedings. This is a fact well known. It was proclaimed by numerous ad hoc committees, and it follows, as I believe my colleague Dr. Jeric explained, from Rule 34.1 of ICSID arbitration rules. As for the payment for the benefit of BD Agro, claimants in the arbitration insisted, at least eventually, that Mr. Ant payments for the benefit of BD Agro were loans extended to the company. So this argument about the so-called loans was given in sort of meandering fashion. At first, the claimants characterized those expenditures as part of their investment operation in their memorial. Then they went on to claim that Mr. Rand's payments were loans extended to an enterprise in accordance with Article 1, Item D of the Canada-Serbia BIT. And finally, they argued that the so-called loans must be treated as a separate category of investment under the treaty. So the tribunal approached the issue as argued by claimants and examined the potential, those transactions as potential investment, as a potential separate and distinct category of investment. Now, the entire claimant's case in this particular instance collapsed once the tribunal refused to recognize Mr. Ant payments as loans. This was done in the award paragraphs 342 and 343. The tribunal sided with respondent and made a factual finding. There was no evidence whatsoever that Mr. Rand ever extended any loans to his own company. As a result, all that Mr. Rand held was a claim to money against BD Agro. Now, this was the crucial point, the turning point in this case, in this particular instance, namely the fact that the tribunal saw Mr. Rand expenditures as simple payments rather than loans, obviously and decisively influenced the tribunal's conclusion on the criteria of duration. It held that the payments did not satisfy the requirement of duration under the convention. Applicant argues that the tribunal erred in holding that the sufficient duration is a part of the objective notion of investment under Article 25.1. Why applicant is wrong has already been explained. But whatever the true meaning of the notion of investment in the ICSID Convention, it is beyond argument that the tribunal's disposition is not unreasonable and thus not a manifest excess of powers. As my colleague opposite said during his opening statement, the Salini controversy will probably outlive us all. So another applicant's contention is that the tribunal was wrong in holding that the payments lacked significant duration. The argument is unsustainable for two reasons. First, the tribunal's finding represents a determination of facts, and as such, it is immune to annulment. This is not something that could be questioned during the annulment proceedings. As you know, there is an almost endless list of ad hoc committees saying that application for annulment is not an opportunity to re-examine the factual metrics of the case. Second, even if the tribunal's factual finding could be re-examined by the committee, it was correct. Namely, no one can seriously argue that payments, a simple wire transfer of money, banking payment lasts for several years, as applicant now tries to argue. Now, only as an alternative argument and for the sake of completeness, the tribunal went on to examine whether the payments would be considered as an investment under the BIT. And this was the fact that was also explained in respondents' written submissions. Serbia consistently argued from its very first submission, from its counter memorial, that Mr. Rand's payments represent other claims to money, explicitly excluded from the protection by Article 1L of the BIT. Once the claimant started referring to these payments as loans, the respondent replied that the so-called loans, even if they existed, would be excluded by virtue of Article 1K2 of the BIT. Namely, they would create a claim to money arising solely from the extension of credit in connection with a commercial transaction, such as trade financing. This is what claimants had to say about Serbia jurisdictional objection in I repeat, 4 written submissions after the issue was raised for the first time. This is their rejoinder and jurisdiction, paragraph 452. I quote, however, Mr. Rand's payments for the replacement of the BD Agro's herd did not constitute a trade financing because they cannot be separated from Mr. Rand's role as the beneficial owner. So one sentence, that's it. Unsurprisingly, tribunal again sided with respondent and accepted both of its arguments. Now, Mr. Rand now claims that the tribunal misapplied the carve-out provisions from Article 1K and 1L of the BIT. We have heard the opposing counsel making an elaborate argument about the position of the carve-out provision in the last sentence of Article 1L of the BIT. Now, members of the committee, there was nothing that prevented Mr. Rand from making this argument during the original proceeding. He never did so. In fact, as you have seen, claimants have effectively failed to formulate any answer to Serbia's jurisdictional objection. It might be that the claimants were convinced that the tribunal would accept their characterizations of loans, of payments as loans. However, the fact remains that Mr. Rand cannot now rely on an argument he failed to use during the arbitral proceeding. As famously stated by the Klöckner-Van committee 40 years ago, an application for annulment cannot be used by a party to complete or develop an argument which it could and should have made during the arbitral proceeding, or help that party retrospectively to fill in gaps in its argument. Now, we have heard Mr. Ranway during his presentation implore you to protect the integrity of ICSID arbitral proceeding. I would, this is of course correct that this is your mission. I would respectfully submit that you have another mission. That is to protect the finality of the award and to prevent the annulment proceeding become the appellate proceeding in its effect. Mr. Rand's argument is not only precluded, it is also meritless. We have heard today that the carve-out provisions, the argument that the carve-out provisions exclude simple cross-border trade interest from the protection in the BIT. The fact is that this is correct. Respondent does not argue otherwise. However, it does not follow from this that each and every payment of an investor for his own company, for the benefit of his own company, is automatically a separate and distinct investment protected under the BIT. Mr. Rand made those payments in furtherance of his investment. And his investment was his ownership stake in BD Agro acquired through the privatization of BD Agro. This much was also admitted by claimants during the arbitration. This is what they had to say about the purpose of the payments. The purpose of the payments was to secure continuity of business operation of BD Agro, and they were required under Article 532 of the privatization agreement. So this is, I ask you to recall that this privatization agreement was precisely the privatization agreement mentioned earlier, the one that gave Mr. Rand the ownership stake in BD Agro. So those payments were never meant to be, and they never were a separate, distinct investment under the BIT. Now, to conclude on the issue of the alleged manifest excess of powers, the applicant's case comes down to the assertions that the tribunal incorrectly interpreted the ICSID Convention or the BIT, that it incorrectly evaluated evidence with regard to the acquisition of the indirect shareholding, and that it incorrectly assessed the facts with respect to the duration requirement for payments made by Mr. Rand. Now, once again, these are all legitimate and reasonable reasons for an appeal, but they have no place in a system which explicitly excludes the appellate review of awards. Finally, even if one could accept, for the sake of argument, that the tribunal erred in its application of the BIT or the convention, it is certain that the tribunal jurisdictional decision do not reach the threshold of being indefensible, untenable, or unreasonable, and they cannot represent the manifest excess of powers. Now, let me just briefly address the issue or the applicant's request for the annulment of the decision on costs. It is undisputed that the committee should not annul a part of the award that has an independent basis and that can be detached from the part of the award affected by the annulable error. In the context of the possible annulment of the decision on costs, as it also follows from the decision relied on by Mr. Rand in his submissions, annulment of the decision on cost should follow only when the partial annulment fully extinguishes the reasons on which the decision on costs rests. This is not the case here. As you know, and as it can be seen from the relevant part of the award, that is paragraph 716 of the award, the tribunal's decision to split equally the costs of arbitration between claimants and respondent was based on several circumstances. These circumstances are, as I said, listed in paragraph 716, and most of those circumstances would remain standing even if this committee accepts every other claim that was submitted by the applicant. This is why the applicant's request must be rejected. This concludes my part of the presentation and also the respondent's opening statement. I thank you for your attention and your patience.
Thank you very much to both sides of the table. What we propose to do now is to take a short recess. The tribunal will have our internal discussion. So the committee will have our internal discussion for a short while and come back to you perhaps with some questions and or some directions relating to whether we require closing written submissions. Okay, so just give us a few minutes. The allotted time is half an hour, but we may not take that long. So just on standby if we call you back. Okay? Okay, thank you very much. Well, welcome back. We have a few questions for you, not too many. We believe you can handle this overnight, and so you can add them to your response tomorrow. I invite first Mr. Al-Hussein to share with you some of the questions that he may have, and thereafter Dr. Annika.
Thank you. Just for the claimant side, when you say that the tribunal identified 6 principles in the methodology, I wonder, it might be of assistance if perhaps you could provide this to us tomorrow, if you could identify by reference to the actual wording in the award where those principles are adopted or can be said to be stated by the tribunal. And one other question, and that's really to both and this is the question of material post-evaluation date. So just perhaps it might be of assistance just to clarify again where each side say the dividing line is between material that is post-valuation and pre. I mean, I presume there shouldn't be a controversy about the fact that you could have a document generated post-valuation date which relates to matters prior to the valuation date, and that wouldn't be excluded. But again, it would be helpful if the parties could set out their positions on where precisely that dividing line is.
Thank you. My question goes to both parties. And my first question concerns the applicant's claim that the tribunal ignored important evidence when it evaluated the construction land, which I understand includes the second Convenex valuation, the Dobanowitz transactions, and the Basova transactions. It would be helpful to the committee if the parties could summarize, maybe in the form of a table or otherwise, where and how the parties and their experts relied on this evidence in the arbitration, including in their written pleadings, in the expert reports, and during the oral pleadings. So that's my first question to both parties. My second question also goes to both parties and concerns the standard for contradictory reasons that may lead a committee to annul an award. It would be helpful to the committee if the parties could, by reference to ICSID annulment jurisprudence, develop a little bit more on the necessary elements of contradictory reasons as a ground that may lead to annulment. In particular, distinguishing such reasoning from contradictory assessment of evidence or potentially mistakes being made by a tribunal that lead to a contradiction in the record. So that's on the legal standard. And my last question goes to the applicant. I would like the applicant to confirm the grounds for annulment he invokes in relation to jurisdiction, both under Article 25 of the ICSID Convention and under the investment definition of the Canada-Serbia BID. Just to clarify. Thank you.
So in relation to Dr. Anneker's first question, if possible, you prepare a table identifying those elements, those 6 factors, and where they are, and what are the parties' submissions to the tribunal. So that will help us see more clearly and the tribunal's decision in award. Okay. For myself, I have a question actually for Serbia, and that is in paragraph 697. I think both parties have read that to us earlier, and it relates to the 30% discount. If I understand the position taken by Ms. Illich is that she applied a 30% discount, taking into consideration various factors, including the size of the land. So if the tribunal take away the element size of the land, how then did the tribunal decide maintaining a 30% discount? Is there a gap, a lacuna, or is there any other explanation that you can find from the award for the tribunal to reach such a solution? Okay, that's to the Serbia. Okay, on that note, of course, on the side of the applicant, you can also join into any of this. Although we say we pose some questions to one party or the other, both sides can respond to it in any manner you like. Okay, so these are the homework we give to you for tonight. Not too heavy, I think, not too much. And we'll see you tomorrow, commencing at 10 o'clock. But before we do that, we also want to indicate to you that based on what we've heard, read so far, the very luminous documents, we are wondering whether you really need post-hearing briefs. So may I ask for your reactions, please? Yes, Mr. Fakaf.
Thank you, Mr. Chairman. Our position is that post-hearing briefs are not needed, and it will be sufficient to have the session tomorrow.
Thank you.
Likewise, respondent's position is that post-hearing briefs are not needed.
Are not needed.
Yes, are not needed.
Okay.
Yeah. And just to clarify for tomorrow, our parties allowed or expected allowed to provide other arguments related to today's discussion in addition to your question. Just to confirm that, I presume yes.
Most certainly, you have 1 hour each tomorrow. Am I correct?
Yes.
1 hour each tomorrow to make any presentation you like in relation to the grounds for the annulment or opposition to it, and including, and then at the same time answer the questions that we pose to you. Yeah. Okay. So if there are no requests for post-hearing brief, I don't think we have any other desire to impose it on you. Okay. So we'll see you tomorrow at 10 o'clock. Very good. Thank you. Have a good evening.